Candy Louise Martin was shot dead on February 16, 2001 in Dorchester County, South Carolina by a high school friend who threw her body in the trunk and set the car on fire, burning her body in the process. Marion Bowman Jr., the murderer, was taken into custody and accused of both murder and arson. Bowman, who killed Martin due to a financial argument, was convicted on both counts and given a death sentence for Martin's murder and a 10-year prison sentence for third-degree arson. Bowman, who had subsequently exhausted his appeals against the capital penalty, was killed by lethal injection on January 31, 2025, while he was incarcerated at Broad River Correctional Institution on death row. The body of 21-year-old Candy Louise Martin was discovered in the trunk of her car in Dorchester County, South Carolina on February 17, 2001. Court sources say that 20-year-old Marion Bowman Jr. was with his sister the previous day when he ran into Martin and her companions. According to reports, Bowman wanted to speak with Martin, a high school friend, so he requested his sister to stop the car. Bowman's sister claims that after asking Martin to give him back some cash and Martin instructed him to wait until she had finished speaking, Bowman responded with, "That bitch be dead by dark." Bowman and his buddies had been partying at a residence that evening when Martin pulled up. Bowman got into her car with his cousin, James Taiwan Gadsden, and all of them drove to a distant location that Bowman had indicated. As they exited the vehicle, Gadsden claimed to have heard Bowman inform him that he wanted to kill Martin. Bowman then pulled out a revolver and fired 3 bullets while following Martin. According to reports, Martin hurried forward to confront Bowman and begged him to spare her life because she had a child to take care of. Bowman fired his gun twice and killed Martin despite her cries for mercy. Then he dragged her body into the bushes around it. Bowman drove Martin's car back to town after threatening Gadsden to keep the fact that he killed Martin a secret, even though he himself boasted about it to others, including Hiram Johnson. After failing to sell the car at the club, he spent the evening driving the vehicle around with other people. Bowman then asked another friend, Travis Felder, to assist him in returning the vehicle to the scene of the murder. Bowman parked the vehicle, then took Martin's body from a nearby bush and stuffed it into the trunk before setting the vehicle on fire. He admitted to Felder that he killed Martin while setting the car on fire. Both men then left the scene. Firefighters discovered Martin's burnt remains after responding to a complaint of a burning car at approximately 3:54 a.m. on February 17, 2001. After Bowman's DNA was discovered in Martin's private area, the police were able to connect him to the murder that same day in the afternoon, and they detained him as a suspect. Dorothy, Bowman's wife, discovered his firearm at home, and the next day an unidentified family member dumped it into the Edisto River from a bridge. Law enforcement later recovered it and identified it as the gun used in the murder. A grand jury formally indicted Marion Bowman Jr. in June 2001 on 1 count of murder and 1 count of third-degree arson. Bowman was put on trial before a jury on May 17, 2002. Walter Bailey led the prosecution. During the trial, Marva Hardy Thomas and Norbert Cummings Jr. represented Bowman. In addition to claiming that the gun might have been planted by investigators to further implicate Bowman as the murderer, the defense contended that Gadsden's testimony should not be believed because he and the other parties in the case had accepted plea deals and had a justification for identifying Bowman as the shooter. After 3 hours of discussion, the jury found Bowman guilty on both charges of murder and arson on May 24, 2002. Citing mitigating evidence that Bowman was raised in a chaotic household with a history of serious alcoholism in his mother's family, and that he started drinking alcohol at the age of 10 and even traded narcotics at the age of 14, the defense requested life in prison for Bowman. However, given the seriousness of the offenses and the aggravating circumstances, the prosecution requested the death punishment. The jury unanimously recommended the death penalty for the murder accusation, and Bowman was condemned to death on the same day of his verdict. Bowman was also found guilty of arson and given a 10-year prison sentence. Following their plea deals with the prosecution, Travis Felder and James Gadsden were also given reduced charges in court over Martin's murder. Gadsden received a 20-year prison term for both wrongdoing of a felony and accessory after the fact of murder, while Felder received a sentence of 3 years in prison, which was later changed to 3 years of probation. Marion Bowman challenged his death sentence to the South Carolina Supreme Court after receiving it. The Supreme Court denied Bowman's direct appeal on November 28, 2005. Bowman's second appeal was denied by the South Carolina Supreme Court on January 10, 2018, and his conviction and death sentence were maintained on March 26, 2010, when U.S. District Judge Terry L. Wooten of the U.S. District Court for the District of South Carolina denied his appeal. Bowman's appeal against the death penalty was denied by the Fourth Circuit Court of Appeals on August 16, 2022. His death sentence was ultimately upheld by the U.S. Supreme Court, which denied his last appeal. Marion Bowman case attracted the attention of civil and anti-death penalty organizations while he was on death row. In addition to stepping up attempts to secure clemency for him, the American Civil Liberties Union had taken up Bowman's cause and conducted an interview with him while he was incarcerated in an attempt to increase awareness of his case and narrative. However, in order to prevent the possible loss of private information or system security breaches, inmates were prohibited from speaking to the media, including in-person media interviews, or having their work directly published in accordance with South Carolina prison regulations. As a result, Bowman's interview tape from the ACLU was forbidden from being aired in the media. In order to address this matter, the ACLU petitioned the federal courts to overturn the ban, arguing that it infringed upon the prisoner's First Amendment rights to free speech and might have protected the South Carolina Department of Corrections from actual public scrutiny regarding potential instances of inmate abuse. The action was dismissed by U.S. District Judge Jacqueline D. Austin on September 5, 2024. The judge maintained that the media did not have special access to sources that should not be made public, and that the state retained the ability to prevent them from doing so. Bowman was one of several death row inmates who filed a lawsuit against the state of South Carolina in 2023, arguing that the electric chair and firing squad were unconstitutional because they were cruel and unusual punishments that would cause the condemned unnecessary pain and suffering. However, the state's attorney retorted that the firing squad and electric chair both adhered to current procedures and that the law did not require that death be immediate or painless. At that time, the lack of lethal injection drugs, the expiration of the state's current drug supplies, and the refusal of several drug companies to sell their drugs to the state for executions resulted in an unofficial moratorium on executions in South Carolina since the state's last execution in 2011. The state government responded to this issue by reintroducing the electric chair and passing new legislation allowing firing squad execution as a backup method of execution in the event that lethal injection was not available. Finally, in September 2023, the state was able to acquire new medication to resume lethal injection execution. A 5-judge panel of the South Carolina Supreme Court rendered its final decision on July 31, 2024, affirming the constitutionality of both the firing squad and the electric chair. The majority of the judges approved the two methods, 4 for the electric chair and 3 for the firing squad. This ruling made it possible for all 32 of the state's death row convicts, including Bowman, to have their executions resumed in South Carolina. 5 condemned prisoners, Bowman, Freddie Eugene Owens, Richard Bernard Moore, Brad Sigmon, and Mikal Mahdi, had exhausted their appeals at the time of this decision and were most likely about to be executed. After one of the 5 prisoners, Freddie Owens, was executed on September 20, 2024, the 13-year moratorium on South Carolina was eventually concluded. Richard Moore was put to death on November 1, 2024, after Owens. Since Bowman was given a death sentence in 2002, it was anticipated that he would be the next condemned prisoner to be put to death. Since Moore was executed, it was assumed that Bowman would be put to death on December 6, 2024, 5 weeks later, and that a death warrant would be issued on November 8, 2024, a Friday, as the state frequently issued death warrants on Fridays. Nevertheless, that date was not the execution date. Bowman and the other 3 convicted prisoners on the execution schedule list reportedly appealed to the state on November 11, 2024, requesting that their executions be postponed until after Christmas and New Year's Day in order to avoid the winter holiday. The South Carolina Supreme Court agreed to give the prisoners a short reprieve on November 14, 2024, and to refrain from issuing any more death warrants until at least January 3, 2025. Bowman and the other 3 inmates on the death row had their possible execution dates rescheduled to 2025 as a result of this agreement. Bowman's death warrant was signed by the South Carolina Supreme Court on January 3, and his execution date was set for January 31, 2025. Bowman was sentenced to death by firing squad, lethal injection, or electric chair, and he was granted until January 17 to choose one of the 3 means of execution. He ended up choosing lethal injection. Bowman was close to Richard Moore, whom he saw as a father figure. Moore, who was executed back in November, taught Bowman to read and play chess, taught him coping mechanisms for the harsh conditions of prison, and encouraged him to avoid worrying about things that were out of his control while he was on death row. The family of Candy Martin responded to Bowman's planned execution by saying that, although they would not be present, they saw it as a measure of justice and closure following the loss of Martin 24 years prior. They said that Bowman had 24 years to continue to connect with his own family, including his daughter and granddaughter, from behind bars, and the family believed Bowman was indeed the real killer, dismissing his claims of innocence. Martin did not have the chance to spend time with her son and become a grandmother. Her son was just 2 years old when she was killed. Marion Bowman filed an appeal to overturn his conviction on the basis of prosecutorial misconduct on December 17, 2024, while his death warrant was still pending in court. Bowman argued that the prosecution's failure to reveal important evidence during his trial, such as the psychological issues and potential confession of one trial witness, as well as the criminal charges pending against another trial witness, hindered his right to a fair and impartial trial and effectively cast doubt on the legality of his conviction and sentence. Additionally, they claimed that Bowman's trial attorneys failed to appropriately defend Bowman, an African American, because they were showing sympathy for the victim, which was a white woman. Bowman also requested that his death sentence be reduced to life in prison without a possibility of parole. His attorney produced signed testimony from a number of former nurses and death row employees who characterized him as a kind giant who had a unique talent for helping mentally ill prisoners engage with psychologists and take their medications as prescribed. For many years, Bowman was the official point of contact between prison officials and death row convicts. Bowman acknowledged having relations with Martin and selling her narcotics in a public statement on January 2, 2025, but he insisted he didn't kill her. He requested on January 8, 2025, that his execution date be postponed until his appeal regarding the constitutional violations of his trial was concluded. His appeal was dismissed by the South Carolina Supreme Court on January 17. Bowman requested additional details regarding the pentobarbital used for fatal injection executions in South Carolina in a different appeal submitted on January 23. Citing Richard Bernard Moore's autopsy results, he voiced his worries that the lethal injection execution in his case would not proceed smoothly. According to the findings, Moore felt as like he was drowning and suffocating throughout the 23 minutes that led to his death, since fluid was discovered in his lungs. In addition, it was disclosed that Moore received 2 substantial doses of pentobarbital, separated by 11 minutes, and Bowman said he needed further details and explanation. The state prosecutors also noted that Bowman could not have chosen the firing squad or electric chair if he had been genuinely worried about the consequences of lethal injection, and an anesthesiologist said that it was typical to find fluid inside the lungs of executed prisoners, particularly those who received lethal injection. On January 28, U.S. District Judge Jacqueline Austin heard the appeal and dismissed it, ruling that Bowman was not entitled to more information about the drugs that would be used in his lethal injection execution. She also said that Bowman could still choose to be executed by firing squad or electric chair if he really had doubts about the effectiveness of the lethal injection drugs. The U.S. Supreme Court rejected his last appeal on January 30, 2025, the eve of his scheduled execution. Bowman, through his attorney, then declared that he would not ask South Carolina Governor Henry McMaster for clemency, saying he would prefer not to live out the rest of his days behind bars for a crime he insisted he never committed. Bowman's family, however, begged the governor for clemency, as he was the only one with the authority to commute his death sentence to life in prison if he agreed. The governor decided to not grant clemency. On January 31st, Bowman glanced at his lawyer across the glass in the witness room for a moment when the curtain to the death chamber opened, then turned back to the ceiling and closed his eyes. He looked up and opened his eyes once more. Bowman puffed his lips as he exhaled once his lawyer had done reading his final statement and poem, which lasted 3 minutes. Those gasps stopped less than a minute later. After 20 minutes, a stethoscope-wielding doctor put a hand on his neck and listened to his chest. Bowman noted in his closing remarks that although death row inmates may be known as the worst of the worst, they have all evolved and matured after their life-altering event. His last words were, "I know that Candy's family is in pain. They are justifiably angry. If my death brings them some relief and ability to focus on the good times and funny stories, then I guess it will have served the purpose. I hope they find peace." His last meal was fried seafood, including shrimp, fish, and oysters, chicken wings and tenders, onion rings, banana pudding, German chocolate cake, cranberry juice, and pineapple juice. These 4 men met their fate in the execution chamber. Their crimes were brutal. Let's uncover what really happened when the clock ran out, what were their last meals, and their last words. The first one to be executed was Stephen Nelson on February 5, 2025 in Texas. Stephen LaWayne Nelson, born February 18, 1987, was a murderer sentenced to death for the 2011 killing of Pastor Clinton Dobson in Arlington, Texas. On March 3, 2011, Nelson stormed into North Point Baptist Church, attacking Dobson and Church Secretary Judy Elliott during a robbery. Dobson was beaten and suffocated with a garbage bag, while Elliott was left severely injured but survived. Nelson stole their belongings, later using Elliott's credit cards for personal purchases. A police investigation linked Nelson to the crime through forensic evidence, including bloodstains on his shoes and fingerprints at the scene. He was arrested after failing to report to his probation officer. Despite his claims that 2 friends committed the murder while he acted as a lookout, the jury found him guilty of capital murder. He was sentenced to death on October 16, 2012. Nelson had a long history of violent crime, beginning in childhood with burglaries, assaults, and property offenses. He spent years in juvenile detention and later faced multiple arrests for theft, assault, and probation violations. While awaiting trial for Dobson's murder, he was accused of killing fellow inmate Jonathan Holden by strangulation. Nelson's appeals were repeatedly denied, and his execution date was set for February 5, 2025. His case has sparked debate among Christian leaders and death penalty opponents, though many, including Dobson's church members, supported his execution. Stephen LaWayne Nelson, 37, was executed by lethal injection and pronounced dead at 6:50 p.m. at the state penitentiary in Huntsville. Just before the injection was administered, Nelson repeatedly expressed his love and gratitude to his wife, who observed through a window nearby. "It is what it is," he remarked, and urged her to enjoy life. She responded by holding up a white service dog, which she was permitted to bring into the witness area. "I'm not scared, I'm at peace," Nelson said. "Let's ride, Warden." As the lethal dose of pentobarbital began, he told his wife, Helen Noah Dubois, whom he married while incarcerated, "Let me go to sleep." After the drug took effect, he uttered the word love, then gasped twice and appeared to try to hold his breath. His head, shoulders, and arms trembled briefly before all movement ceased. He was officially declared dead 24 minutes later. Texas does not offer special last meal requests anymore. Nelson simply had to choose something to eat from a menu that all other inmates had for that day. Just one day later, the second man executed was Demetrius Frazier, February 6, 2025, in Alabama. Demetrius Terrence Frazier was a serial rapist and convicted murderer on death row in Alabama for the 1991 rape and murder of Pauline Brown, a 40-year-old woman he killed during a robbery. He was also convicted in Michigan for the 1992 murder of 14-year-old Crystal Kendrick, whom he shot while attempting to assault her. In addition to these murders, Frazier was accused of raping 8 women in Michigan, with a jury convicting him of 2 assaults. Arrested in Detroit for Kendrick's murder, he later confessed himself to killing Brown. Frazier received 2 life sentences in Michigan in 1993 for Kendrick's murder and other crimes. In 1996, Alabama sentenced him to death for Brown's murder. He spent 18 years in Michigan's Alger Correctional Facility before being transferred to Alabama's Holman Correctional Facility in 2011. Scheduled for execution by nitrogen hypoxia on February 6, 2025, Frazier attempted legal appeals, arguing that the method was inhumane. A federal judge denied his request to halt the execution. His mother also pleaded for his transfer back to Michigan, but her request was denied as well. Demetrius Frazier, 52, was pronounced dead at 6:36 p.m. at a South Alabama prison, and the method of execution was nitrogen hypoxia. His last words were, "First of all, I want to apologize to the family and friends of Pauline Brown. What happened to Pauline Brown should have never happened. I love everybody on death row. Detroit strong." In his final words, Frazier also criticized Michigan Governor Gretchen Whitmer for not intervening after appeals for him to be returned to serve out a previous life sentence in Michigan. Strapped to a gurney with a blue-rimmed gas mask covering his face, the execution began around 6:10 p.m. following a final check of the mask by a corrections officer. For the first minute or two, Frazier moved his outstretched palms in a circular motion. At 6:12 p.m., he stopped moving his hands, appeared to grimace, and took a gasping breath. A minute later, he lifted both legs a few inches off the gurney before lowering them. His breathing slowed to irregular breaths by 6:14 p.m., and by 6:21 p.m., there was no visible movement. The curtains to the execution chamber were closed at 6:29 p.m. Alabama Corrections Commissioner John Hamm later stated that the gas flowed for approximately 18 minutes and instruments showed Frazier had no heartbeat 13 minutes after the gas started. Hamm believed Frazier lost consciousness quickly and that the subsequent movements, including raising his legs and sporadic breaths, were involuntary. In the hours leading up to his execution, Frazier spent time with his mother, sister, and legal team. For his final meal, he chose Taco Bell, which included burritos and a Mountain Dew. Real quick, before we continue, please subscribe to the channel. It will help me a lot since this will become my main source of income starting April. We've got 19 cats, 2 dogs, 2 hedgehogs, and a bunny that need food. I appreciate you all. Thank you for being here. Let's move on. The third person executed was James Ford on February 13, 2025 in Florida. James Dennis Ford was a convicted murderer and death row inmate in Florida, sentenced for the 1997 double murder of Gregory and Kimberly Malnery in Charlotte County, Florida. On April 6, 1997, Ford, Greg's co-worker, lured the Malnerys to a sod farm under the pretense of a fishing trip. Once there, he shot Greg in the head, slashed his throat, and bludgeoned him. Kimberly attempted to secure their 22-month-old daughter Miranda in the truck before Ford overtook, raped, and brutally killed her. He abandoned the child, who was later found alive but dehydrated and covered in insect bites after 18 hours alone. Ford was arrested on April 17, 1997, and convicted on March 8, 1999 of 2 counts of first-degree murder, child abuse, and sexual battery. Despite his defense arguing diminished responsibility due to drug and alcohol use, a jury recommended the death penalty by an 11-1 vote. He was sentenced to death on June 3, 1999, alongside additional prison terms for the sexual battery and child abuse charges. Over the years, Ford's appeals were repeatedly denied, including by the Florida Supreme Court and the U.S. Supreme Court. On January 10, 2025, Governor Ron DeSantis signed his execution warrant, and Ford was scheduled to be executed on February 13. Ford, 64, was executed by lethal injection at the Florida State Prison in Rayford and was pronounced dead at 6:19 p.m. This marked the first execution in Florida in 2025 and the fourth in the U.S. this year. His execution took place less than an hour before Texas was scheduled to execute Richard Lee Tabler at 7 p.m. for the 2004 double murder of two men. Officials reported that Ford did not speak any final words to those present at the execution, but did leave a written statement. His statement read, "Hugs, prayers, love. God bless everyone." For his last meal, Ford had steak, macaroni and cheese, fried okra, sweet potato, pumpkin pie, and sweet tea. 3 family members visited him on Thursday morning. As the injection began, Ford's chest began to heave, and then all movement gradually stopped. A few minutes later, a staff member shook him and shouted, "Ford, Ford." This was to check if he was still conscious, but there was no response. Moving over to Texas, in the same day, Richard Tabler was executed. He was born on February 5, 1979, and he was a spree killer convicted of 4 murders in Killeen, Texas in 2004. On November 26, Tabler and accomplice Timothy Dawn Payne killed nightclub manager Mohammed Amin Rahmouni and his associate Haitham Frank Zayed over a dispute. 2 days later, Tabler murdered 2 teenage dancers from the same club, Amanda Benefield and Tiffany Dodson, fearing they knew about the prior killings. Tabler was sentenced to death for the first 2 murders, while Payne received life in prison. Tabler had a troubled upbringing marked by parental neglect, academic struggles, and an ADHD diagnosis. He had prior convictions for burglary, assault, and escape attempts. After his arrest for the 2004 killings, he initially confessed but later retracted it. His appeals spanned nearly 2 decades, with multiple attempts to waive them, though courts questioned his mental competence. His final appeal was denied by the U.S. Supreme Court on October 7, 2024. While incarcerated, Tabler illegally obtained a cell phone, using it to threaten Texas State Senator John Whitmire, leading to a lockdown and his mother's arrest for smuggling contraband. He was sentenced to an additional 10 years for these offenses. Tabler was scheduled for execution on February 13. Texas executed 46-year-old Richard Lee Tabler with a lethal injection of pentobarbital in the presence of his mother and sister among the witnesses. He was pronounced dead at 6:38 p.m., and in his final statement, Tabler expressed regret, saying, "There is not a day that goes by that I don't regret my actions." He directly addressed the victims' families, saying, "I had no right to take your loved ones from you. I am deeply sorry." His statement continued, offering words for the victims' families, saying, "If you feel that this is what you need to get closure, I pray it helps you find that." He also expressed hope for forgiveness, saying, "I just hope that one day you find that forgiveness to forgive me for taking your loved ones from you." Tabler thanked several prison staff members by name for their compassion and support, saying, "Your love and support have allowed me the opportunity to change and become a better man and rehabilitate." He reassured his loved ones, lawyers, and supporters, saying, "This isn't the end. This is only the beginning." He then thanked God, saying, "I thank God for allowing me to seek him out and finding him, showing that this isn't about me. We are all here today because of my actions, but in the end, it comes down to God, praising him and giving honor to him. I know this will be the end of this life, but it will be the beginning of my ultimate life in heaven." As the lethal drugs began to take effect, he said, "I'm sorry," one more time before his breathing became rapid. After several breaths, all movement ceased. Brad Keith Sigmon, March 7, South Carolina. On April 27, 2001, a week after splitting with his ex-girlfriend, Sigmon used a baseball bat to bludgeon David and Gladys Lark, ages 62 and 59 respectively, to death. They were the parents of his ex-girlfriend. The South Carolina Supreme Court issued Sigmon's death warrant on February 7, 2025, and set March 7, 2025 as the day of his execution. The court allowed him until February 21 to decide whether he wanted to be executed by firing squad, electrocution, or lethal injection. The electric chair would be selected automatically if he refused to select the technique. To the surprise of everyone, he selected the firing squad. He said he was terrified of the effects of a lethal injection, and he was very concerned because previously executed inmates had struggled for several minutes before being pronounced dead. Brad Sigmon was executed by firing squad at the Broad River Correctional Institution on March 7, 2025. At 6:05 p.m., the firing squad, made up of volunteer prison staff, shot Sigmon, who heaved in the chair and flexed his arms for a few seconds before going limp. He was declared dead at 6:08 p.m. Beneath the chair, there was a bowl to collect his blood. His attorney, religious advisors, the relatives of his victims, and 3 reporters were among those present for the execution. There was no warning or countdown before the squad opened fire on Sigmon, who was strapped to a chair with his legs shackled, wearing a hood over his head, and had a target over his chest, according to AP News journalist Jeffrey Collins, who was present and saw the execution. According to witnesses, Sigmon mouthed to his lawyer that he was okay even though his jaw was held in place with a sling. Collins reported seeing a jagged red spot about the size of a small fist in the vicinity of Sigmon's shooting spot after the bullets. Sigmon's chest moved 2 or 3 times, he added. There was no sound outside the rifle crack. Another reporter, Anna Dobbins, who was also present at the execution, described seeing a splash of blood as the bullet struck his body. Additionally, she said that Sigmon's body moved for a few seconds following that. She added that before being shot, he showed no outward indications of fear or trepidation. Weapons loaded with .308 Winchester ammo were used by the firing squad that performed the execution. This type of ammunition was made especially to fragment when it struck a target, destroying key organs like the heart and resulting in death almost immediately. Sigmon was the first person to be executed by firing squad in the United States since Ronnie Lee Gardner's June 2010 execution in Utah, and the fourth since 1976. Sigmon chose KFC for his final meal, which included fried chicken, green beans, gravy-topped mashed potatoes, biscuits, cheesecake, and sweet tea. He initially requested 3 buckets of fried chicken so that he can split them with the other inmates, but the officials denied his wish. His last words were, "I want my closing statement to be one of love and a calling to my fellow Christians to help us end the death penalty. An eye for an eye was used as justification to the jury for seeking the death penalty. At that time, I was too ignorant to know how wrong that was. Why? Because we no longer live under the Old Testament law, but now we live under the New Testament." Jessie Hoffman, March 18, Louisiana. On November 26, 1996, Jessie Hoffman Jr. kidnapped, essayed, and murdered a woman in Louisiana. He was only 18 years old. The 28-year-old advertising expert Mary Elliott had just left work that day and was on her way to the downtown New Orleans Sheraton parking garage where she usually left her car before work. Hoffman, a valet at that garage, met Elliott when he got there and directed the woman in her own car at gunpoint. He forced Elliott to drive to a nearby ATM and withdraw some cash. She gave him $200, and Hoffman asked Elliott to take them to a remote area of St. Tammany Parish. After forcing her to march to a patch of dirt, Hoffman essayed her while brandishing a gun. After making her kneel on a makeshift pier beside the Middle Pearl River, Hoffman shot her in the head to end her life. He then left her naked body there and disposed of her belongings and the murder weapon. Elliott's body wasn't found until 2 days later on Thanksgiving Day, November 28, 1996. A duck hunter discovered her remains and reported the finding to the authorities. Elliott's husband was able to identify his wife, who had gone missing after failing to show up for dinner. Authorities were also notified by a couple who found Elliott's belongings and clothes in an abandoned lot. Among the documents were 3 ATM receipts connected to the same ATM from which Elliott had taken out money for Hoffman. The police were able to arrest Hoffman based on the description of a man who was seen with Elliott in the ATM photographs. Eventually, Hoffman admitted his involvement in the killing. Hoffman's execution was the first in which Louisiana used nitrogen hypoxia as method of execution. Only 4 other executions in the U.S. have involved the use of nitrogen gas, and those were all carried out in Alabama, the only other state with a protocol for the technique. Hoffman was declared dead at the Louisiana State Penitentiary at 6:50 p.m. after refusing to make a final statement before the gas started to flow. While one witness described the inmate convulsing during the procedure, authorities said that the nitrogen gas flowed for 19 minutes during what one official described as a flawless execution. Hoffman also declined to have a special last meal. Aaron Gunches, March 19, Arizona. On November 14, 2002, Gunches went to his girlfriend's place. Upon his arrival, he discovered that she had a confrontation with her ex-husband, Ted Price, who had come to see her earlier that day. Price had been struck in the face by a telephone and was lying on the floor, confused. Gunches then had his girlfriend and her friends help him get into his car, ostensibly with the intention of dropping Price off at a bus stop. However, Gunches soon found out that he did not have enough money to buy Price a bus ticket. Then Gunches and a friend drove Price into the desert. As Price exited the vehicle, Gunches shot him 4 times, killing him. Gunches entered a guilty plea to Ted Price's murder in 2004, and he received a death sentence in 2008. Along the years, he had asked for his execution to be carried out several times. On March 19, he was lethally injected with pentobarbital and was pronounced dead at 10:33 a.m. According to witnesses, Gunches had no last words before the execution while sitting upright on a gurney, wrapped in what appeared to be a white onesie and tucked in with a sheet. Following the fatal injection, the inmate snorted and took several deep breaths. Gunches' final meal consisted of 2 sandwiches, French fries, onion rings, a double Western bacon cheeseburger, and baklava for dessert. Wendell Grissom, March 20th, Oklahoma. Grissom and Jessie Jones broke into the house of a mother of 2 who also had a visitor, her close friend Amber Matthews. Grissom shot Drew Koff several times, but she managed to run away and survived. Her friend Amber was killed while she was hiding in a bedroom with Drew's 2 toddlers. Fortunately, the children were not harmed. At the Oklahoma State Penitentiary in McAllister, Grissom, 56 years old, was declared dead at approximately 10:13 a.m. following a fatal injection of a 3-chemical cocktail. His final moments were witnessed by his own family and numerous of his victims' relatives, according to state corrections officials. Grissom's final meal was a pint of vanilla ice cream, a pint of Coca-Cola, and a Canadian Bacon Supreme pizza. His final statement was a long one, in which he apologized for his actions and expressed his regret. In part, his last words said, "I pray that you all can forgive me, not for my sake, for your sake. It is the only way you will find God in this." Edward Thomas James, March 20th, Florida. He was sentenced to death for the September 1993 murders of an 8-year-old girl and her grandmother in Castleberry, Florida. James was renting a room from Elizabeth Ann Dick, the mother of a friend of his. James came home from a party on September 20th, 1993, to discover that Dick's 4 grandchildren were sleeping in the living room. He took Toni Marie Neuner, 8 years old, by the neck and choked her until she passed out. Then he carried her to his bedroom and essayed her before placing her between his bed and the wall. Later, she died from the strangulation. James then went to Dick's bedroom, where he repeatedly stabbed her with a knife and struck her in the head with a candlestick. Wendy, Tony's sister, who was 9 years old, came to the bedroom as she heard her grandmother screaming. Wendy was restrained by James and placed in the restroom. After retrieving a butcher knife from the kitchen, he went back to Dick's bedroom and stabbed her in the back. James took her car after having a shower and stealing jewels from Dick's bedroom. James, 63 years old, received a 3-drug injection in Florida State Prison and was declared dead at 8:15 p.m. He said he did not want to make a final statement while he waited for the injection. His arms flinched when the medications were given, and he began to breathe heavily before becoming still. I couldn't find what his last meal was, but the rule in Florida is that inmates can order anything that is under $40, and if the desired meal is made locally. Christopher Sepulvado, March 17, Louisiana. Sepulvado was on death row for 33 years for brutally beating and scalding to death a 6-year-old boy back in 1993. He was supposed to be the first inmate to be executed with nitrogen gas in Louisiana on March 17, but he passed away from natural causes in the prison infirmary on February 22. He was 81 years old. This April, 4 death row inmates took their final breaths, each one leaving behind a trail of devastation that can never be undone. Mikal Tanzi, April 8, Florida. After more than 2 decades on Florida's death row, Mikal Tanzi was executed for the brutal 2000 murder of 49-year-old Janet Acosta. In the days leading up to his death, his legal team launched a final, unusual appeal, arguing that his morbid obesity could make lethal injection unbearably painful. But the courts ultimately rejected the claim, and on April 8, the state carried out the execution as scheduled. On April 25, 2000, Janet Acosta was sitting in her van during her lunch break at the Japanese Gardens in Miami, reading a book. Tanzi, stranded in the city and trying to get back to Key West, approached her and asked for a cigarette and the time. Then, without warning, he punched her in the face and forced his way into the van. Holding her at knife point with a razor, Tanzi drove off, keeping her subdued by gripping her wrist. At a gas station in Homestead, he gagged her with a towel and bound her with rope from the van. He threatened to kill her if she made a sound. Acosta handed over $53 in cash, and Tanzi tried to use her ATM card to buy cigarettes and a Coke. He then coerced her into performing oral sex. After realizing he had broken her teeth during the initial assault, he stopped. Later, in Tavernier, Tanzi again used threats to get Acosta's PIN number and withdrew money from her account. He also stopped to buy more razor blades and duct tape. By around 6:30 p.m., they had reached Sugarloaf Key. Fearing Acosta could identify him, Tanzi decided to kill her. On a remote road in Cudjoe Key, he strangled her with rope, pausing to muffle her face with duct tape before continuing until she was dead. He left her body in a wooded area where he believed it wouldn't be found. After the murder, Tanzi used her ATM card to shop, eat, and visit friends in Key West. He planned to change the van's appearance, buy drugs, and go into hiding. But on April 27, police, who had been surveilling the van after Acosta was reported missing, caught him returning to it. He had receipts from her bank account in his pocket. Tanzi immediately confessed to the crime. In custody, he provided detailed statements and showed investigators where he had discarded the body, rope, and duct tape. He initially pleaded not guilty, but changed his plea before trial, admitting to first-degree murder, carjacking, kidnapping, and armed robbery. During the penalty phase, defense attorneys presented evidence of severe childhood trauma and mental illness. Experts testified that Tanzi had been essayed starting at age 8 and was diagnosed with PTSD, bipolar disorder, ADHD, and antisocial personality disorder, among others. His mother recalled signs of emotional damage following his father's illness and death, as well as the prolonged abuse by an older boy. Despite this, the jury unanimously recommended the death sentence. Tanzi was also linked to the 1999 murder of Carolyn Holder in Massachusetts. Although he was never tried in that case, investigators believed he stabbed and strangled the 36-year-old woman. Prosecutors declined to pursue the case since he was already sentenced to death in Florida. As his execution date approached, Tanzi's lawyers filed a last-minute appeal, arguing that his extreme obesity could interfere with the sedative used in Florida's lethal injection protocol. They claimed the drug, etomidate, might not keep him unconscious, putting him at risk of experiencing the feeling of being burned from the inside while paralyzed and unable to react. The state pushed back, saying the drug had been successfully used in numerous executions, and there was no evidence it would fail in Tanzi's case. Circuit Judge Timothy Cohen dismissed the appeal, and the Florida Supreme Court declined to intervene. Despite the dramatic claims, the execution proceeded as scheduled. Tanzi had a spiritual advisor as his only visitor after he got up at 4:45 a.m. on the day of his execution. His final meal consisted of a candy bar, ice cream, corn, bacon, and pork chop. At Florida State Prison, Tanzi received a 3-drug injection and was declared dead at 6:12 p.m. He made the final statement saying, "I want to apologize to the family," prior to reciting a Bible passage just before the drugs started to flow. His chest heaved for 3 minutes, then stopped, and the corrections officers shook his shoulders and called his name twice to see if he was still conscious, but he was not. Mikal Mahdi, April 11, South Carolina. Mikal Mahdi remained on death row for the 2004 killing of a South Carolina police officer during a violent, multi-state crime spree. Originally from Virginia, Mahdi embarked on a 3-day rampage in July 2004 that left 2 men dead and included carjackings, robberies, and multiple assaults. On July 15, 2004, Mahdi murdered 29-year-old convenience store clerk Christopher Jason Boggs in Winston-Salem, North Carolina. 2 days later, he carjacked a man in Columbia, South Carolina, and fled to a nearby farm in Calhoun County. There, he encountered 56-year-old James Myers, an off-duty police captain, and killed him before setting his body on fire. Mahdi evaded capture for 4 days after Myers' death, but he was arrested in Florida on July 21, 2004. He was extradited to South Carolina, where he was later found guilty and sentenced to death in 2006. In 2011, he was transferred to North Carolina, tried for the murder of Boggs, and received a life sentence without parole. Despite multiple appeals, Mahdi's death sentence was upheld. The South Carolina Supreme Court signed his death warrant on March 14, 2025, scheduling his execution for April 11, 2025. Mahdi chose to die by firing squad. He was the second person in the state to do so this year, stating it was the least cruel of the available methods. On July 14, 2004, 21-year-old Mahdi stole Virginia license plates, a station wagon, and a .38 caliber handgun from a neighbor before heading south. The next day, he entered a convenience store in Winston-Salem, picked up a beer, and fatally shot Christopher Boggs in the face when the clerk asked for ID. Mahdi fired another round into Boggs's body before fleeing with a beer. After the murder, Mahdi drove to Columbia, South Carolina. There, he carjacked Corey Pitts and armed himself with a revolver. He then swapped the license plates with the ones he had stolen in Virginia. After 35 minutes of driving, Mahdi stopped at a gas station and attempted to use a credit card to pay for fuel. When the pump refused the card and employees became suspicious, Mahdi fled on foot. Later that day, he arrived at a farm in Calhoun County owned by Captain James Myers of the Orangeburg Department of Public Safety. While Myers celebrated family birthdays at the beach, Mahdi rummaged through the property's workshop looking through firearms and watching TV. When Myers returned to the farm, Mahdi ambushed him with a .22 caliber rifle, held him hostage, and ultimately shot him 9 times. He then poured diesel on Myers' body and set it ablaze. Mahdi fled in Myers' police-issued truck, taking multiple firearms with him. Myers' wife, Amy Tripp Myers, also a law enforcement officer, became alarmed when he failed to return home. She discovered his burned body and alerted authorities. Florida police apprehended Mahdi on July 21, 2004, after spotting him driving Myers' truck. He attempted to flee on foot with one of Myers' weapons, but ultimately dropped it and surrendered. In 2009, while incarcerated at Lieber Correctional Institution, Mahdi and serial killer Quincy Allen plotted to kill a corrections officer. They crafted homemade knives and attacked guard Nathan Sasser after luring him to the prison yard. Though seriously injured, Sasser survived the stabbing, but later developed PTSD and left law enforcement. While Mahdi and Allen were charged for the assault, prosecutors dropped the case because both men were already sentenced to death. Quincy Allen's sentence was eventually overturned, and in July 2024, he was resentenced to life after accepting a plea deal. Mahdi, however, remained on death row. In 2023, Mahdi joined a group of inmates who sued South Carolina over the use of the electric chair and firing squad, claiming both methods amounted to cruel and unusual punishment. The courts dismissed the case. On March 28, 2025, Mahdi officially chose the firing squad as his method of execution, saying he feared being burned and mutilated in the electric chair or suffering a prolonged death by lethal injection. His lawyer called it the least evil of the three choices. Mahdi filed a last-minute appeal, arguing that his original defense team failed to present mitigating evidence about his traumatic upbringing. The court rejected the appeal, agreeing with prosecutors who maintained that Mahdi's background did not excuse his crimes. Born on March 20, 1983 in Virginia, Mahdi's childhood was marked by instability and neglect. His father, Sharif, had converted to Islam, married a 16-year-old, and struggled with the law and employment. Mahdi's mother left in 1986, and by 1991, Mahdi and his brother were sent to live with relatives. At 8 years old, Mahdi moved in with an uncle in Maryland and attended school in Baltimore. He struggled academically and behaviorally, especially with reading comprehension and respect for authority. School reports noted low self-esteem and poor interpersonal skills. In 1992, Mahdi was involuntarily hospitalized for a suicide threat. He later moved back in with his father and brother in 1997 and committed his first burglary that same year. Convicted of multiple charges, Mahdi spent time in juvenile detention before moving to Richmond with his mother. In 2001, Mahdi was sentenced to 93 months in prison for assaulting a Virginia police officer. Released in May 2004 and placed on 15 years probation, he launched his deadly spree just 2 months later. At 6:05 p.m. on the day of his execution, Mikal Mahdi, 42 years old, was declared dead after the firing squad placed a hood over his head and fired 3 bullets into his heart at once. Witnessing the execution, his lawyer described it as barbaric and described it as a horrifying act that belongs in the darkest chapters of history, not in a civilized society. Mahdi refused to give a final statement. According to a reporter who was present at the execution, Mahdi screamed as the bullet struck him and then let out 2 groans around 45 seconds later. Mahdi died less than 4 minutes after the rounds were fired. His last meal was a ribeye steak, mushroom risotto, broccoli, collard greens, cheesecake, and sweet tea. Moises Sandoval Mendoza, April 23, Texas. He had been found guilty of the 2004 murder of 20-year-old Rochelle Tolson in Collin County, Texas. Mendoza strangled her, kept her body hidden behind his house for several days, and later burned and buried it in a remote rural area beneath a brush pile. Both Mendoza and Rochelle had attended Farmsville High School and graduated in 2001, though they didn't know each other well at the time. They reconnected around 6 weeks before the murder while attending Collin County Community College. On the night of March 17, 2004, Mendoza was reportedly drinking heavily at a friend's house with 2 other men. By the next day, Rochelle had gone missing. Her 6-month-old baby was found alone at home, which led her family to immediately report her disappearance to the police. The scene inside her home was chaotic, with overturned furniture suggesting a possible struggle or abduction. Authorities later learned that Mendoza had picked Rochelle up from her home after the baby had gone to sleep. He confessed to a friend, Stacy Marie Garcia, that he had strangled Rochelle. In her statement to law enforcement, Garcia said Mendoza admitted to essaying her, stabbing her in the neck, and initially hiding her body behind his home on Jackson Street. He later relocated the body, wrapped in a tarp, to Brushy Creek after being questioned by police. The remains were discovered when a man hunting for arrowheads spotted 2 feet sticking out from a brush pile. The body had been badly burned and dental records were required for identification. Mendoza reportedly told Garcia that he had torched the body to destroy any fingerprints or evidence. He also claimed that he and Rochelle were in a relationship, though friends of the victim refuted this. According to them, Rochelle had only recently met Mendoza at a party and she was not interested in him romantically. Some speculated that her rejection may have triggered the violence. The brutal murder shocked the small community of Farmsville. Neighbors and acquaintances described Mendoza as polite, hard-working young man who often helped his father. Many were stunned that he could be responsible for such a horrific crime. However, Mendoza did have a documented history of violent behavior. In April 2003, police records showed he had been charged with misdemeanor assault after allegedly attacking his sister in their front yard. The case was dismissed after his sister chose not to pursue charges. Additionally, Mendoza was awaiting trial for 3 counts of aggravated robbery with a deadly weapon in connection to gunpoint robberies at Richland College in Dallas in March 2003. In January 2005, Mendoza was also charged with several counts of child essay, but those charges were dropped after his conviction for capital murder. Following his conviction, Mendoza filed numerous appeals, claiming ineffective legal representation during his trial and post-conviction proceedings. However, both federal courts and the Texas Court of Criminal Appeals denied his appeals. After years of legal battles, the court determined he had exhausted all options and set his execution date. Mendoza was executed by lethal injection on April 23, closing a chapter on a case that left deep scars in the local community and among those who knew and loved Rochelle Tolson. His last words were directed towards his family and the victim's family. "I am sorry for having robbed you of Rochelle's life. I am sorry for that. I know nothing that I could ever say or do would ever make up for that. I want you to know that I am sincere. I apologize." The family members of the victim were her parents, one brother, a cousin, and an uncle. Her daughter was not present at the execution. Mendoza's family was seen very distraught in the witness room. His last words towards them were, "I love you, I am with you, I am well and at peace. You know that I am well, and everything is love." His wife, his sister, and 2 friends were there in his final moments. Texas doesn't offer any special final meals since 2011, so he ate what was on the menu that day. James Osgood, April 24, Alabama. Osgood was executed by lethal injection at the William C. Holman Correctional Facility in Atmore, Alabama. His execution followed a series of legal proceedings and appeals stemming from his conviction for the brutal 2010 essay and murder of 44-year-old Tracy Lynn Brown in Chilton County. The Alabama Supreme Court had authorized the execution after a request was filed by the Alabama Attorney General's office on February 11, 2025. The court granted the request on March 6. Governor Kay Ivey subsequently set the official execution date. Osgood and his then-girlfriend, Tonya Van Dyke, attacked Brown at her home. Court documents revealed that Brown, who was Van Dyke's cousin, was coerced at gunpoint to engage in sex acts. She was then savagely beaten, stabbed in the back, and had her throat slit. Her body was discovered on October 13, 2010, after she failed to show up for work. Both Osgood and Van Dyke were arrested and charged in connection to the crime. Van Dyke received a life sentence without the possibility of parole, while Osgood was convicted on 2 counts of capital murder committed during the course of both first-degree essay and first-degree sodomy. Although Osgood's conviction was upheld by the Alabama Court of Criminal Appeals, his sentencing was initially overturned due to errors in the judge's instructions to the jury during the penalty phase. The case was sent back to Chilton County Circuit Court for a new sentencing hearing. However, in a rare move, Osgood requested to be sent back to death row before the resentencing could take place. When the judge asked why he would make such a request, Osgood reportedly said he believed an eye for an eye and felt he deserved to die for what he had done. Tracy Brown's murder shocked the community and devastated her family. The nature of the crime was particularly brutal and personal, given the family connection between the victim and one of the perpetrators. Osgood's execution was the last to be carried out in the U.S. in April 2025, closing a dark chapter in a case that had haunted Chilton County for nearly 15 years. At 6:09 p.m., the witness room's curtains opened. Osgood turned to face relatives seated in a witness room as the execution began. As he passed out, friends and family wept softly. Wearing a khaki prison uniform and strapped on a gurney, Osgood spoke about his victim in his final moments. His last words were, "I haven't said her name since that day. I was not sure if I should say it. Tracy, I apologize." Around 6:15 p.m., his head fell back onto the gurney as his breathing grew laborious and heavy. By approximately 6:18 p.m., his breathing was no longer detectable. He was declared dead a few minutes later. 5 attempts were made to attach the 2 necessary IV lines to Osgood. His final meal was pizza. He declined his lunch tray but ate breakfast and some snacks. On Thursday, Osgood had meetings with 11 individuals, including his sister and daughter, other relatives, friends, and a lawyer. He also had a phone conversation with someone. This May, 5 men were put to death across the US, and each case was darker, more twisted, and more tragic than the last. Let me take you inside their last moments. Jeffrey Hutchinson, Florida, May 1st, 2025. Jeffrey Glen Hutchinson was sentenced to death for the 1998 murders of his girlfriend and her 3 children in Crestview, Florida. A former Army Ranger and Gulf veteran, Hutchinson struggled with his mental health after returning from combat. His first marriage ended in divorce, and the second relationship with Renee Flaherty eventually turned fatal. On September 11, 1998, after an argument with Renee, Hutchinson left their home, went to a bar, and told the bartender he was angry. Less than an hour later, he returned with a shotgun and fatally shot Renee, 32, and her 3 children, Geoffrey, 9, Amanda, 7, and Logan, 4, in their home. All victims were shot in the head. Geoffrey was also shot in the chest. Hutchinson called the police right away and he was arrested at the scene. He was charged with 4 counts of first-degree murder. At trial, he claimed that masked intruders committed the killings, then later said it was a crime of passion committed under the influence of alcohol. The jury didn't buy any defense. On January 18, 2001, Hutchinson was found guilty on all charges. The judge sentenced him to life in prison for Renee's murder and death for the killings of the children, citing their young age and the brutal nature of the crime, especially Geoffrey's, whom Hutchinson shot twice. Despite appeals citing mental illness and military trauma, his convictions and sentences were upheld. The Florida Supreme Court ruled the domestic nature and lack of prior violence didn't outweigh the severity of the crimes. Governor Ron DeSantis signed the death warrant of Jeff Hutchinson on April 1, 2025. The Flaherty family murders were among the most devastating in Okaloosa County's history. In the aftermath, grief counselors were sent to the children's school to support the community. Hutchinson was executed shortly after 8 p.m. on Thursday at Florida State Prison in Rayford, using the state's standard 3-drug trial injection protocol: etomidate, rocuronium bromide, and potassium acetate. He was pronounced dead at 8:14 p.m., according to the Florida Department of Corrections. This was Florida's 4th execution of the year and the 15th in the U.S. in 2025. Hutchinson declined to give a final statement and reportedly mumbled to himself as the execution began, according to the Associated Press. His last meal consisted of salmon, mahi-mahi, asparagus, baked potato, and iced tea. Hutchinson's family fought till the very end to save his life and postpone the execution. There was some evidence that he may not have committed the murders, and he actually maintained his innocence all these years. One of the most compelling pieces of evidence in this case was the fact that he had blood spatter under his shoes, something that couldn't have happened if he was the shooter. Another thing that his loved ones tried to explain was that Hutchinson was not actually the one that called 911, but it was in fact the real murderer who was trying to frame Hutchinson. They said that the reason he was put into this situation was that some people were trying to involve him in robberies because he had military expertise and he refused to help them. I will admit that this was one case in which I did have doubts about his innocence. I know that there are many things pointing out that he was the killer, but at the same time, there may be some details that were not properly investigated. I'm not saying he was innocent, but I do wish that things were crystal clear. A lot of you guys will say that the justice system in the US is based on proving guilt beyond reasonable doubt, and I know that's how it works. I support the death penalty, but my personal belief is that nobody should be executed without knowing 110% that there is no possibility whatsoever of punishing the wrong person. Glen Rogers, Florida, May 15, 2025. Nicknamed the cross-country killer and the Casanova killer, Glen Rogers was convicted of first-degree murder in two separate trials for the killings of two women, one in Florida in 1997 and another in California in 1999. He was also suspected in several other homicides across the U.S. His killing spree began on September 28, 1995, and after his first confirmed murder, he was added to the FBI's 10 most wanted fugitives list. Rogers received death sentences both in Florida and in California. After spending nearly 30 years on death row, he was finally executed on May 15, 2025. Rogers was born in Hamilton, Ohio, one of 7 children of Edna and Claude Rogers, a hydropulp operator at the local Champion paper mill. His brother Clay is among his surviving siblings. Glen was expelled from junior high school before turning 16. Following his expulsion, Rogers impregnated his 14-year-old girlfriend, Deborah Ann Nix, and they got married. The couple had a second child in 1981. Nix, however, filed for divorce in 1983, citing physical abuse. Authorities in Hamilton, Ohio, suspected Rogers of the 1993 murder of an elderly man, after which he left the state and reappeared in California. In 1995, he was linked to the killings of 4 women across California, Mississippi, Florida, and Louisiana. Rogers was arrested in Kentucky on November 13, 1995. Initially, he claimed responsibility for nearly 70 murders, but later retracted the statement, saying he was just joking and had not killed anyone. Let's talk about the victims. Mark Peters, Hamilton, Ohio. On January 10, 1994, the remains of 71-year-old Mark Peters, a retired electrician and veteran, were found in a family-owned cabin in Kentucky. Peters had taken Rogers in before he went missing in October 1993. Rogers vanished around the same time. Peters' body was found tied to a chair and concealed under furniture. Police were led to the scene by Rogers' brother Clay. Sandra Gallagher, Los Angeles, California. On September 28, 1995, Rogers was seen with 33-year-old Sandra Gallagher at a bar in Van Nuys. The next day, her strangled and burned body was found in her truck near Rogers' apartment. He fled afterwards and was suspected of additional murders in other states. He was convicted of her murder in June 1999 and sentenced to death in California. Linda Price, Jackson, Mississippi. Linda Price met Rogers at the Mississippi State Fair in fall 1995. They briefly lived together. The 34-year-old single mother vanished just before Halloween, and her body was later found in her bathtub. She shared traits with Rogers' other suspected victims, including red hair and being in her 30s. Guys, it started raining and there's a lot of thunder going on, so if you're hearing those noises, I'm sorry. Tina Marie Cribbs, Tampa, Florida. On November 5, 1995, Cribbs was last seen leaving a bar with Rogers. Her body was found 2 days later in a motel bathtub, having been stabbed multiple times. Fingerprints and evidence linked Rogers to the crime. He was arrested on November 13 while driving her car. Rogers claimed she had lent him the vehicle. In July 1997, he was convicted of her murder in Florida and sentenced to death. Andy Giles Sutton, Bossier City, Louisiana. A known acquaintance of Rogers, Sutton was found dead in her apartment on a punctured waterbed. Rogers fled the state, leading police on a 13-mile chase in Kentucky before being captured. His arrest was caught on film by a local TV crew. After being sentenced to death for Cribbs' murder, Rogers' scheduled 1999 execution was delayed due to multiple appeals, all of which were ultimately denied. He challenged the conviction on several grounds, including prosecutorial misconduct and improper testimony. His final appeal was denied in 2011. On April 15, 2025, Florida Governor Ron DeSantis signed Rogers' death warrant, setting the execution for May 15. Rogers was the 5th Florida inmate scheduled for execution this year. He attempted to stop the execution by citing childhood essay and concerns about the drugs used in the lethal injection, but the Florida Supreme Court denied the appeal on May 9. The U.S. Supreme Court also rejected the final appeal on May 14. Rogers, 62 years old, was executed according to plan at Florida State Prison, and he was pronounced dead at 6:16 p.m. His final meal was pizza, chocolate cake, and soda. He was the 16th person executed in the US in 2025. In his final statement, Rogers addressed the victims' families and then President Donald Trump. I know there's a lot of questions that you need answers to. I promise you, in the near future, the questions will be answered, and I hope in some way will bring you closure. President Trump, keep making America great. I'm ready to go. Matthew Johnson, Texas, May 20, 2025. On the morning of May 20, 2012, 76-year-old Nancy Judith Harris arrived early for her shift at the Final Whip convenience store in Garland, Texas. Harris, a beloved grandmother known for her kindness and routine, had no idea her workday would end in a brutal and senseless act of violence. Shortly after she began her shift, a man named Matthew Lee Johnson entered the store carrying a container of lighter fluid and a lighter, items he would soon use to commit an unthinkable crime. Surveillance footage from inside the store later revealed Johnson approaching Harris at the counter. Without warning, he began pouring lighter fluid all over her, demanding access to the cash register. Harris, trying to comply in hopes of avoiding escalation, she opened the register as instructed. Johnson then grabbed the contents, bills, coins, and even Harris's personal belongings, including her ring, 2 cigarette lighters, and cigarette packs. As Harris stood with her back to him, Johnson ignited the lighter fluid, setting her ablaze. As flames consumed her body, Harris ran to a nearby sink and desperately tried to extinguish the fire. She attempted to remove her burning shirt, leaned over the sink again, but was still engulfed in flames. Meanwhile, Johnson casually walked out of the store, taking candy from the counter as he exited. Outside, Harris managed to flee the building, screaming for help. A passerby who witnessed the horrifying scene rushed to her side with a fire extinguisher and attempted to put out the flames. Emergency responders arrived shortly after, finding Harris severely burned but conscious and able to provide a description of her attacker, a heavy-set black man with short hair and a round face. Law enforcement quickly canvassed the area and located witnesses who had seen a man matching Harris's description attempting to enter nearby homes. Approximately an hour later, officers apprehended Johnson after a short foot chase. He was found in possession of the stolen cash and items taken from the store. Initially charged with robbery and assault, his charges were upgraded to capital murder after Harris succumbed to her injuries 5 days later, on May 25, 2012, at Parkland Memorial Hospital's burn unit. Nancy Harris was a deeply loved member of her community. Her family described her as a warm and caring person, someone who spent her Fridays with her granddaughters in what they called Nini days, which included trips to the dollar store, lunch at McDonald's, and games at home. She had previously overcome health scares and was regarded as a resilient and joyful woman who found immense pleasure in small, simple routines with her family. Matthew Lee Johnson, born on September 17, 1975 in Dallas County, had a long history of criminal behavior and personal instability. Raised in a difficult and reportedly abusive environment, he began engaging in criminal activity by age 15. His rap sheet included car theft, resisting arrest, and attacking police officers. Over the years, his offenses escalated, including a 2011 theft from an employer. Despite his criminal history, Johnson had periods of stability. He was married and had 3 daughters by the time of his arrest. However, his life remained marked by addiction and instability. Johnson stood trial for capital murder in Dallas County beginning on October 28, 2013. Prosecutors argued that Johnson deliberately and cruelly murdered Harris during the course of a robbery. They presented extensive evidence, including the store's surveillance footage, eyewitness testimonies, and physical evidence, such as the stolen items found in Johnson's possession. Prosecutors emphasized Johnson's calm demeanor after setting Harris on fire as a sign of his cold and calculated nature. During the punishment phase of the trial, his attorneys tried to argue for mercy. He took the stand and claimed that he was high on drugs at the time of the attack and that he never intended to actually harm Harris. He just wanted to scare her. He expressed remorse and said he would like to live to see his daughters grow up. The defense presented psychological and expert testimony highlighting Johnson's long history of drug addiction, which reportedly began during his adolescence. They also introduced evidence of childhood trauma, including essay and testimonies from family members who detailed his struggles and attempts to overcome his addiction. The prosecution countered with evidence of Johnson's long criminal record and the brutality of the crime. They argued that Johnson posed a continuous threat to the society and that he deserved the harshest punishment possible. During victim impact statements, Harry's family addressed the court with raw emotion. Her children and grandchildren described the agony of losing her in such a violent way. One of her sons vowed to witness Johnson's execution, while another stated that he would never forgive Johnson, hoping the memory of Harris's screams would haunt him forever. Her granddaughters also expressed disbelief that Johnson felt any true remorse and emphasized the deep void left by Harris's absence. On October 30, 2013, the jury unanimously found Johnson guilty of capital murder. Less than 2 weeks later, on November 8, he was sentenced to death. Johnson reportedly showed no emotion as the verdict was read, and his attorney said that it was because Johnson expected this outcome. Over the next decade, Johnson pursued multiple appeals at the state and federal levels. Each was ultimately rejected. In November 2015, the Texas Court of Criminal Appeals upheld his conviction and sentence, rejecting 65 separate claims of error. In June 2016, the U.S. Supreme Court declined to hear his case. Further efforts for relief were denied in 2019 by the Texas Court of Criminal Appeals. In 2022, they were also denied by the U.S. District Court for the Northern District of Texas, and in 2023 by the Fifth Circuit Court of Appeals. His final appeal to the U.S. Supreme Court was denied on February 20, 2024. By early 2025, Johnson had exhausted all possible legal remedies. In January, a Dallas County judge signed his death warrant, scheduling his execution for May 20, 2025, exactly 13 years to the day after he set Nancy Harris on fire. On May 16, just days before his execution, the Texas Board of Pardons and Paroles denied Johnson's request for clemency. His attorney confirmed that no further appeals would be made. On the day of his execution at the Huntsville unit, Johnson was given the opportunity to speak. In his final statement, he turned to Harris's family and said, "As I look at each one of you, I can see her on that day. I please ask you for forgiveness. I never meant to hurt her." He was executed by lethal injection and pronounced dead at 6:53 p.m. Central Standard Time. Because he was executed in Texas, he did not get a final special meal. Benjamin Ritchie, Indiana, May 20, 2025. On September 29, 2000, Benjamin Donnie Ritchie fatally shot 31-year-old officer William Toney, a police officer in Beech Grove, Indiana. Ritchie was arrested shortly after and faced multiple charges, including the murder of a law enforcement officer. He was found guilty on August 10, 2002, and sentenced to death by a Marion County judge on October 15, 2002. Ritchie's legal team pursued numerous appeals, all of which failed. In his final efforts, he argued that his death sentence should be overturned due to severe mental health disorders and cognitive impairments. These, he claimed, were the result of childhood abuse, personal drug use, and his mother's substance abuse while pregnant with him. However, the Indiana Supreme Court ultimately denied his request to file a successive post-conviction relief petition. The court instead approved the state's request to set an execution date, which was carried out on May 20, 2025 at Indiana State Prison, where Ritchie had been incarcerated. Ritchie's life was fraught with adversity from the beginning. Born on May 3, 1980, he never knew his biological father. His mother, Marion Martin, worked as a stripper and struggled with addiction to drugs and alcohol, which continued during her pregnancy. By the time Ritchie turned 3, she had abandoned him twice. Her husband, Donald Peoples, took custody of Ritchie's older half-brothers, but left Benjamin behind upon learning he was not the boy's father. Initially named Benjamin Peoples, he was later adopted by Verna and Oscar Ritchie and took their surname. Ritchie's childhood and adolescence were marked by academic and behavioral difficulties. He repeated the first grade and left school in 9th grade. He began receiving counseling from a church minister as early as 3rd grade and was admitted for treatment at Community North Hospital by age 10. Diagnosed with bipolar disorder and other cognitive issues, Ritchie's struggles were attributed to his unstable upbringing and the lasting effects of prenatal exposure to drugs and alcohol. In August 1998, he was convicted of burglary. By the time of the shooting in 2000, he was no longer in prison but under supervised probation. That September, he and two associates stole a white van from a Beech Grove gas station. About 2 hours later, Officer Matt Hickey identified the vehicle and began pursuit. He was joined by officers Robert Mercury and William Toney. During the chase, only Ritchie and 20-year-old Mikal Greer remained in the stolen van. When the vehicle stopped in a residential yard, both fled on foot. Officer Hickey apprehended Greer while Officer Toney chased Ritchie. Ritchie drew a firearm and shot Officer Toney 4 times. One of the bullets pierced above the officer's bulletproof vest, fatally wounding him. Officer Toney had served on the police force for just 2 years. Ritchie was arrested the next day at the home of Michael Moody, the third participant in the theft. Prosecutor Scott Newman soon confirmed that the state would seek the death penalty. Due to media interviews where Ritchie claimed the shooting was accidental, a story supported by a friend, a gag order was imposed to prevent further public discussion before the trial. Initially, Mikal Greer also faced murder charges. However, as part of a plea agreement, he pled guilty to lesser charges, including aiding a criminal, theft and trespassing, and agreed to testify against Ritchie. Greer faced a maximum sentence of 8 years. Moody was convicted of car theft and possessing an unlicensed firearm with a maximum 4-year sentence. Ahead of trial, Ritchie's attorneys filed a motion citing the 2002 U.S. Supreme Court decision in Ring v. Arizona, which held that only juries, not judges, can impose a death sentence. They argued Indiana's laws allowing judicial override were unconstitutional. Judge Patricia Gifford agreed in part, declaring judicial overrides unconstitutional, though she upheld the broader legality of the death penalty, allowing it to remain on the table. Ritchie's trial began on August 5, 2002, after jury selection at the end of July. The pretrial gag order expired when the proceedings started. On the trial's second day, Greer testified against Ritchie. The jury found Ritchie guilty of murder, car theft, carrying an unlicensed firearm, and resisting arrest. During the sentencing phase, Ritchie's defense highlighted his traumatic childhood and mental disabilities, arguing he deserved leniency. The prosecution rejected these arguments, asserting that many endure hardship without committing murder. After over 3 hours of deliberation, the jury unanimously recommended the death penalty. Ritchie reportedly laughed upon hearing the verdict. On October 15, 2002, Judge Gifford formally sentenced 22-year-old Ritchie to death. Prior to the sentencing, Officer Toney's widow gave a victim impact statement accusing Ritchie of cowardice and expressing hope that he would suffer in prison until his execution. Ritchie spent over 2 decades on Indiana death row. In 2014, he was among just 11 inmates awaiting execution. By 2020, the number had dropped to 8. And it's raining. Again. In 2024, it came to light that Ritchie had been in a 4-year relationship with a Swedish woman who first learned about him through a documentary. She even traveled to visit him in prison. They briefly discussed an escape plan which Ritchie called off to protect her. After their relationship ended, she struggled with substance abuse but eventually recovered and became a mother. Ritchie's legal battles persisted for years. The Indiana Supreme Court denied his first appeal in 2004 and his second in 2007. He alleged ineffective legal representation, which the court rejected. In 2017, the U.S. Supreme Court dismissed his final appeal. In September 2024, Indiana's Attorney General requested the court schedule Ritchie's execution. At the time, he was one of 4 death row inmates who had exhausted all appeals. He was also the only one convicted of killing a police officer, while 2 others awaited trial for similar crimes. Ritchie's attorneys submitted a final motion in response to the death warrant, claiming previous legal counsel had failed to explore potential fetal alcohol spectrum disorder or childhood lead exposure. While the court considered the arguments, Indiana resumed execution by putting Joseph Corcoran to death in December 2024, ending a 15-year hiatus caused by drug shortages. On April 15, 2025, the Indiana Supreme Court rejected Ritchie's final motion and scheduled his execution for before dawn on May 20, 2025. In the majority opinion, Justice Geoffrey Slaughter stated that the new evidence about cognitive issues wouldn't have changed the jury's decision. Chief Justice Loretta Rush dissented, arguing that the evidence warranted further review. Two clemency hearings were scheduled on May 5 and May 12, 2025. During the first, Ritchie apologized for the murder, claiming he had changed and wanted to contribute positively if spared. At the second hearing, Officer Tony's family and friends urged the board to proceed with the execution. On May 14, both the parole board and Governor Mike Brown denied clemency. Ritchie also petitioned the U.S. Supreme Court and the Seventh Circuit Court of Appeals for a delay. Both appeals were denied by May 19, the night before his execution. On May 20, 2025, at the age of 45, Benjamin Donnie Ritchie was executed by lethal injection at Indiana State Prison. The Indiana Department of Corrections reported that Benjamin Donnie Ritchie's execution began shortly after midnight. He was declared dead at 12:46 a.m. following the administration of a single dose of pentobarbital. For his final meal, he chose Olive Garden's tour of Italy, which features fettuccine alfredo, lasagna, and chicken parmigiana. His final words were, "I love my family, my friends, and all the support I've gotten. I hope they all find peace." Information about the execution of the 45-year-old was limited, as media were not allowed to observe the procedure. Steve Schutt, Ritchie's defense attorney and one of the few witnesses, told the Indiana Capital Chronicle that Ritchie reacted sharply as the execution started. He jolted upward, lifting his shoulders and twitching violently for around 3 seconds. He didn't fall back down immediately. It seemed like he slowly settled back and then remained still for a few minutes before the curtains were drawn. Oscar Smith, Tennessee, May 22, 2025. Oscar Franklin Smith was sentenced to death in Tennessee for capital murder, and he was executed after years of delays. Originally set to be executed on April 21, 2022, his execution was temporarily halted by Governor Bill Lee due to issues with the lethal injection protocol. The murders occurred on October 1, 1989, when Smith's estranged wife, Judy Roberts Smith, and her sons, Chad and Jason Burnett, were killed in Nashville. Judy was shot in the neck and stabbed multiple times. Chad was shot in the eye, chest, and torso, and Jason was stabbed in the neck and abdomen. A sharp tool called an awl was found at the scene, but the murder weapons, a .22 caliber revolver and a knife, were never recovered. At the time, Smith and Judy were already separated, and Smith had taken out life insurance policies on all 3 victims. The couple had 3-year-old twins. Several co-workers testified that Smith had threatened Judy's life on numerous occasions and expressed resentment towards her sons, allegedly saying she favored them over the twins. During the attack, the family attempted to call 911, and Chad was reportedly heard screaming, "Frank, no." At trial, investigators claimed to have found a bloody palm print matching the 2 missing fingers Smith had. However, Smith later hired an expert who questioned the reliability of that evidence and pointed out errors in the original analysis. Smith was sentenced to death on July 26, 1990. His execution was initially planned for December 3, 1990 by electric chair, but legal appeals delayed it. Over the years, he became part of a broader legal challenge, arguing that lethal injection is cruel and causes extreme suffering. His execution dates in 2020 and 2021 were postponed due to the global context at the time. In 2022, Smith's legal team requested clemency from Governor Lee, seeking a sentence of life without parole. As he had been sentenced before 1999, Smith could choose his method of execution, either the electric chair or lethal injection. He declined to choose, so the state defaulted to lethal injection. In early 2022, Smith attempted to reopen his case based on new DNA evidence found on a weapon, but a Tennessee court denied his motion. Subsequent appeals to the Tennessee Supreme Court were also rejected. Governor Lee initially chose not to intervene, but later he issued a temporary reprieve upon discovering the state had not followed the correct procedures for testing the lethal injection drugs. Specifically, they had not been tested for endotoxins. This led to a suspension of all executions in Tennessee for the rest of that year and a third-party review of the process. By late 2024, the state had implemented a revised lethal injection protocol using pentobarbital. In March 2025, a new death warrant was signed for Smith, setting his execution for May 22 the same year. As he once again refused to choose a method, the state proceeded with lethal injection. Smith was executed as planned. He was pronounced dead at 10:47 a.m., and in his final statement, he maintained his innocence, saying, "Someone needs to tell the governor the justice system doesn't work. I didn't kill her." For his last meal, he requested hot dogs, tater tots, and apple pie with vanilla ice cream. After the execution, Judy's siblings expressed ongoing grief and emphasized the lasting pain of domestic violence, a tragedy shared by many other families. Smith was the 19th person executed by the U.S. this year. June was a chilling month on death row. From last meals to final words, these are the people that were executed and the crimes that put them there. Gregory Hunt, June 10, Alabama. On August 2, 1988, Karen Lane was brutally murdered in the apartment she shared with Tina Gilliland, located at 105 Elliott Heights in Cordova, Alabama. Lane had been dating Gregory Hunt, Gilliland's cousin, for approximately 1 month prior to her death. On the afternoon of August 1, 1988, Hunt was at the apartment with Lane when Gilliland's ex-husband arrived with his fiancée, Shirley Romine, to pick up his and Gilliland's 2 children. Gilliland was taking a nap at the time. According to Romine, after Lane left the room, Hunt expressed frustration, stating he was tired of everything and planned to move back to Miami, Florida. He also said, "She makes me so mad I could kill that bitch." When Gilliland woke up around 6 p.m., Hunt was gone. Shortly after, Gilliland and Lane left in Gilliland's beige 1986 Yugo. After stopping to buy cigarettes, they went to the residence of Gilliland's then-fiancé, Clinton Cook, in Parrish, Alabama. Upon arrival, around 7 p.m., they saw Hunt's van outside. Gilliland entered the residence while Lane left in the Yugo. Inside, Hunt noticed Lane in the Yugo and asked Gilliland why Lane didn't get out of the car. Gilliland replied that Lane had gone to her mother's home. Hunt then left. Later that evening, Hunt visited the home of James Molinex and Hortensia Ovalle in Jasper, Alabama, arriving around 8 or 8:30 p.m. While there, Hunt discussed his frustration with Lane, stating he needed to do something about the problem. As he left, he said he was going to f somebody up. Returning to Cordova, Hunt called Cook's residence around 9:40 p.m. from his mother's home at 405 2nd Street. He asked Gilliland where Lane was. Gilliland told him Lane said she was going to her mother's home. Hunt warned, "I know how you women are. You better tell me where she's at." When Gilliland replied she didn't know, Hunt insisted, "You better tell me where she's at or it is going to be detrimental to you." He added he was ready to go back to prison if necessary. Later that night, Lane's father, W.O. Sanders, discovered that a house Lane had previously occupied was on fire. Sanders, who lived about 200 yards from that house, testified he heard Hunt's van pass his house twice that night. After the second pass, he discovered the fire. After calling Gilliland and driving by Sanders's house, Hunt returned to Jasper. When Deborah Twilley returned home from work at 11 p.m., Hunt was there using her telephone. Twilley noted Hunt appeared to have been drinking. He asked to borrow her car, explaining, "I've got some stuff I need to do. It's not wise that I'm seen in my van." After Twilley refused, the conversation turned to Lane. Hunt said he was tired of her and admitted to burning her house, stating he poured gas on it and set it on fire. He asked Willie to drive him to Cordova to check if the house had burned down completely, expressing hope that it had. Around midnight or 12:30 a.m. on August 2, Amy Cherie Long saw Hunt in his van chasing Lane, who was driving the beige Yugo at high speed in Cordova. Hunt then returned to his mother's home and called Cook's residence at 12:55 a.m., speaking with Cook. Hunt said something had happened materially and that Karen's family and Karen would be upset with him because of what he had done. He stated he would have to move back to Florida, but added people didn't screw him over like this and get away with it. Around 1 a.m., Hunt called Lane's mother, Betty Jo Sanders, asking if Karen was there. When Sanders said no, Hunt mentioned Karen's house had burned and that she would be hurt because she loved that place. He also said he had been looking for Karen, stating she was running stop signs and lights, and all he wanted to do was say hi to her, but she wouldn't stop. Hunt also threatened violence against Gilliland, saying, "You know, Tina is scum. I'm going to throw her up against the wall, do you know what I mean? I won't do to mess with. I grew up in violence. I know what it's all about." Shortly before 2 a.m., Mary Turner, who lived at 103 Elliott Heights, in an apartment separated from Gilliland's by one other apartment, heard a noise that sounded like glass breaking. She saw Hunt reach his hand into the window of Gilliland's apartment and then enter through the adjacent door. After Hunt entered, Turner heard peculiar noises, one that sounded like somebody had hit the floor hard and another like someone sliding a chair across the floor. Around 2 a.m., she heard the door slam and saw Hunt leaving the apartment. At 2:44 a.m., Cook received another call from Hunt, who was calling from Gilliland's apartment. Hunt told him that Karen was lying there in the kitchen floor and asked Cook to get somebody up there to get her to the hospital. Karen Lane's body was discovered in Gilliland's apartment later that morning. After calling Cook, Hunt returned to Jasper. Molinax and Ovalle testified they found Hunt's van outside their home around 6 a.m. According to Molinax, Hunt was in the van and, as Molinax left for work, he raised up a little bit and then went back down. Later that day, Hunt drove to Cullman, Alabama, to Jack and Jean Kilpatrick's house. From there, around 7 or 8 p.m., Hunt called his brother-in-law, Russell Davenport, in Cooper City, Florida. Hunt said he had been out partying with a woman and got into a fight with her. He stated, "I don't think I killed her. I'm not sure how she was when I left her. I checked with the hospitals and newspapers, and I can't find anything else about her at all." Hunt was arrested later that month. In October, his sister, Loretta Martin, visited him in jail. Martin testified they discussed Karen Lane's death. During their conversation, she asked Hunt, "You did kill her?" Hunt said, "Yes, I did." He explained they had a fight on the night of her death. He hit her, lost his head, and couldn't control himself. Hunt told Martin he had gone out looking for Lane and chased her through Cordova. When Martin asked if he had been drinking, he said he had been drinking and taking some medication prescribed by a doctor. In June 1990, while detained in jail pending trial, Hunt also confessed to his cellmate James Carr Sanders. Sanders testified Hunt said he and Lane had fought because she was dating someone else. He had knocked her down, choked her, kicked her, and inserted a broomstick into her private area. After that, he saw she was bleeding, became scared, and called the police. Dr. Joseph Embry, who performed the autopsy, testified Lane sustained approximately 60 injuries, including about 20 to the head. Her injuries included lacerations, external bruises, bruises to the brain, fractured cheekbones, nasal bones broken into small pieces, 12 rib fractures on each side, a fractured breastbone, bruises to her heart and lungs, a bruised pancreas, a 3/4-inch tear in her aorta, and 3 tears in her liver. She also had bleeding in the muscles in her neck and numerous bruises and lacerations on her arms, legs, chest, and back. Larry Hughes, a serologist with the Alabama Department of Forensic Sciences, analyzed swabs from Lane's private parts and mouth. The oral swabs revealed Lane's mouth contained genetic material. Hughes stated that quantity and condition of the material suggested that it was deposited very close to the time of the death, if not post-mortem. Gregory Hunt, 65, was pronounced dead at 6:26 p.m. at a South Alabama prison on June 10. He was executed by nitrogen hypoxia. An inmate is forced to breathe pure nitrogen gas throughout the execution process, depriving them of oxygen, which is essential for survival. Hunt, strapped to a gurney and wearing a blue-rimmed mask that covered his face, did not offer any last words, but seemed to use his fingers to make the thumbs up and peace signs. It was unclear exactly when the gas started to flow, but it started after 5:55 p.m. At 5:57 p.m., Hunt jerked, gasped, and lifted his head off the gurney for a moment. At approximately 5:59 p.m., he moaned and raised his legs. After 6:05 p.m., he stopped moving and took 4 or more gasping breaths with extended intervals in between. The gasps and trembling motions were similar to earlier nitrogen executions in Alabama. Critics claim that although the state maintains that demotions are expected, they demonstrate that the execution procedure does not guarantee a speedy death. A number of Lane's family members were present at the execution. Hunt was one of the death row inmates in Alabama with the longest sentence. Last month, he told the media that he wanted to help other prisoners and that discovering religion in prison helped him become free of his demons. Since 1998, he has been teaching a weekly Bible class. Hunt refused his final dinner tray, which included hot dogs, vegetables, potatoes, and black-eyed peas. However, earlier that day, he was served a lunch tray containing bologna, black-eyed peas, carrots, and fruit punch. On the same day, but in another state, another inmate faced his death. Anthony Floyd Wainwright, June 10, Florida. On April 27, 1994, Carmen Gayhart, a 23-year-old nursing student and mother of 2 children, was abducted in Lake City, Florida. Born on September 2, 1970, Gayhart had been working towards her nursing degree while also raising her young children. That day, she vanished without a trace, setting off a series of events that would later shock the state. The individuals responsible for her disappearance were Anthony Floyd Wainwright, born October 22, 1970, and Richard Eugene Hamilton, born February 16, 1963. Just a few days before the crime, both men had managed to escape from a prison facility in North Carolina. Carmen was declared missing when she failed to arrive at her children's daycare to pick them up, something that was extremely out of character for her. At the time, she was attending nursing classes at Lake City Community College and was last observed in a parking lot not far from campus earlier that day. Her failure to collect her kids immediately raised alarm among her loved ones. Her husband, her father, and classmates began a frantic search for her, but when their efforts yielded no leads, she was officially reported missing. Unbeknownst to them, Carmen had already been abducted at gunpoint by Wainwright and Hamilton. She had just finished loading groceries into the Ford Bronco she had been driving in the parking lot of a Winn-Dixie store when the 2 escapees targeted her. Just 2 days prior to this horrifying incident, Wainwright and Hamilton had broken out of a minimum security facility in Carteret County, North Carolina. Wainwright had been serving a 10-year sentence for burglary, while Hamilton was serving a 25-year term for armed robbery. After their escape, they stole a vehicle and broke into a home where they obtained 2 rifles. Armed and on the run, the men fled southward into Florida, where they ultimately encountered and abducted Carmen Gayhart. After capturing her, the 2 men ditched their original stolen vehicle at a lumber yard along U.S. Route 41. They then took off in Carmen's Ford Bronco with her still alive in their custody. They transported her to a secluded forested area located behind the Fuel City truck stop off State Route 6 in Hamilton County, Florida. Hidden away from view in a remote and isolated location, they subjected her to a violent and degrading essay. According to Richard Hamilton's later testimony, Wainwright attempted to strangle Carmen following the assault. To ensure she was dead, Wainwright then shot her twice in the head using a bolt-action .22 caliber rifle, killing the young mother. After leaving her body in the woods, the pair fled, continuing their attempt to escape capture. During court proceedings, each man accused the other of being the one who strangled and shot Carmen. The next day, on April 28, 1994, the 2 fugitives were located in the vicinity of Brookhaven, Mississippi. When approached by a state trooper from the Mississippi High Patrol, Wainwright and Hamilton opened fire, resulting in a shootout. Both suspects were wounded but survived their injuries. Hamilton was shot in the face, while Wainwright sustained a gunshot wound elsewhere. At the time of their arrest, they were still driving the Ford Bronco that had belonged to Carmen Gayhart. However, despite recovering the vehicle, authorities had yet to find any trace of Carmen herself. Following his arrest, Hamilton waived his right to contest extradition and was quickly returned to Columbia County, Florida. Once back in Florida, he underwent an extensive interrogation by detectives from the Columbia County Sheriff's Office regarding Carmen's disappearance. During this interrogation, Hamilton confessed to the crime and offered detailed information about what had occurred. He even went so far as to sketch a map identifying the location where they had taken Carmen, essayed her, attempted to strangle her, and ultimately shot her. However, despite drawing the map, Hamilton was unable to specify the exact city or county where the crime took place. In his statement, he admitted that both he and Wainwright had taken part in the essay, but claimed that Wainwright alone had committed the actual murder by shooting Carmen. On May 2, 1994, Tina Wheeler, a dispatcher with the Hamilton County Sheriff's Office, recognized the area depicted on Hamilton's map as being near State Route 6. Acting on this tip, Deputy Sheriff Mel Black and Albert Jones traveled to the identified area around 4:30 in the morning to search for Carmen's body. During their search, Jones noticed a strong foul odor and notified the investigators. As the sun rose at around 7 a.m., authorities discovered Carmen's decomposing remains. The case was officially taken over by the Hamilton County Sheriff's Office, and her body was sent to the District 4 Medical Examiner's Office in Jacksonville for further analysis. After the body was transported, a more detailed search of the crime scene was conducted. Dr. Margarita Arruza, the medical examiner overseeing the case, observed that several of Carmen's teeth and her hyoid bone were missing. Based on her findings, she advised law enforcement to revisit the crime scene. Following this recommendation, investigators returned and were successful in recovering some of the missing teeth as well as the hyoid bone, critical in corroborating evidence of strangulation. In the weeks following their arrest, both Wainwright and Hamilton were formally charged with a series of serious felonies, including first-degree murder, sexual battery, robbery, and kidnapping. In July 1994, a grand jury indicted both men on all counts. The state attorney for Florida's 3rd Judicial Circuit, Jerry Blair, announced that the state would pursue the death penalty, citing the particularly brutal and premeditated nature of the crimes, along with the aggravating circumstances such as the essay, kidnapping, and Carmen's vulnerability. The case drew substantial public interest as the horrifying nature of the crimes generated widespread outrage. Carmen's family made it known that they supported the pursuit of capital punishment for both men. Due to the extensive media coverage and difficulty in assembling an impartial jury in Hamilton County, the court opted to move the trial to Clay County, where a jury was more easily seated. While they were held at the Clay County jail awaiting trial, both Hamilton and Wainwright repeatedly expressed a desire to escape. Authorities received intelligence indicating that the pair was actively plotting a breakout that allegedly included a plan to murder a correctional officer during their attempt. Given the seriousness of these threats, both men were moved to maximum security cells, and additional precautions were taken. During court appearances, stun belts were fitted to both inmates and kept activated to ensure control and prevent any violent outbursts or escape attempts. The separate trials for both men began in May 1995. On May 30 of that year, both juries returned guilty verdicts against Hamilton and Wainwright for the kidnapping, essay, and murder of Carmen Gayhart. Just 2 days later, on June 1, 1995, both juries recommended the death penalty. The jury in Wainwright's case was unanimous in their decision, while Hamilton's jury returned a 10-2 majority in favor of execution. On June 12, 1995, Circuit Judge Vernon Douglas sentenced both men to death in the electric chair. In addition to their death sentences, the judge handed down 3 consecutive life terms each for the additional crimes committed against Carmen. Hamilton's direct appeal to the Florida Supreme Court was rejected on October 23, 1997. His second appeal, filed in 2004, was also denied. On March 3, 2017, his petition to a writ of habeas corpus was rejected, and on February 8, 2018, his final post-conviction appeal was turned down, confirming his death sentence. Wainwright's direct appeal was similarly dismissed by the Florida Supreme Court on November 13, 1997. His subsequent appeal in 2004 was also denied. On November 13, 2007, the U.S. Court of Appeals for the 11th Circuit rejected his case, and in 2008, the Florida Supreme Court dismissed the third appeal. Most recently, in July 2023, the 11th Circuit again rejected Wainwright's latest appeal, which included new DNA evidence. The court ruled that the DNA findings did not effectively counter the trial evidence or demonstrate Wainwright's innocence. On January 13, 2023, Richard Hamilton died at the age of 59 while incarcerated at Union Correctional Institution in Florida. He had spent roughly 28 years on death row. The Florida Department of Corrections did not release a cause of death. Following his passing, Wainwright remained the sole surviving perpetrator of the 1994 crime. On May 10, 2025, Florida Governor Ron DeSantis signed Wainwright's death warrant, setting the execution date for June 10, 2025. Anthony Wainwright, 54, received a lethal injection at Florida State Prison. Around 6:10 p.m., the execution got underway. At 6:14 p.m., Wainwright's shoulders trembled a few times, and he blinked and inhaled deeply before going motionless. Gayhart's husband, son, and mother-in-law were among the 17 family members who witnessed Wainwright's death at 6:22 p.m. Wainwright did make a final statement, but it was inaudible from the witness room. On the morning of his execution, he was offered a special last meal, but he politely declined, opting only for the regular prison breakfast. 2 days later, John Hanson was executed in Oklahoma. On the evening of August 31, 1999, a horrifying sequence of violent crimes unfolded in Tulsa County, Oklahoma. Two men, George John Hanson, also known by the alias John Fitzgerald Hanson, and Victor Cornell Miller, embarked on a crime spree that included the carjacking and the brutal murder of a 77-year-old woman, as well as the cold-blooded killing of a man who had the misfortune of witnessing their criminal activity. That same evening, Mary Agnes Bowles, a 77-year-old retired banker from Tulsa who had once served as president of the St. Francis Hospital Auxiliary, became a victim of Hanson and Miller. She had been at the parking lot of the Tulsa Promenade Mall when the two men abducted her. Earlier that day, the duo had already committed 2 liquor store robberies and were actively looking to expand their crime spree. They targeted Bowles specifically for her vehicle, intending to use it to carry out additional robberies. During the abduction, Miller took control of the driver's seat while Hanson held Bowles at gunpoint in the back seat as they drove away from the mall. Their journey took them to a dirt pit near the town of Owasso, a location owned by Gerald Max Thurman, a 44-year-old businessman who operated a trucking company in the area. By coincidence, Thurman was on site making a delivery when he noticed a suspicious vehicle, Bowles' car, repeatedly circling the pit. Concerned, he made a phone call to his nephew to report what he had observed. Tragically, moments after the call, he encountered the man. In an attempt to eliminate him as a witness, Miller approached Thurman and shot him 4 times with a revolver, leaving him critically wounded. While this was happening, the pair continued on with Bowles in the car. Eventually, they pulled over at a roadside location. There, Hanson forced Bowles out of the vehicle and mercilessly shot her multiple times, between 4 and 6, using a semi-automatic handgun. She was killed instantly. After the murder, Hanson and Miller tried to conceal her body by covering it with branches before fleeing the area. Thurman's shooting did not go unnoticed. Nearby individuals who heard the gunshots alerted authorities, leading them to discover Thurman's location shortly after the incident. Although he was still alive when found and rushed to a hospital, he succumbed to his injuries 2 weeks later, on September 14, 1999. Bowles, on the other hand, was not discovered until a week after her abduction. Her body was found on September 7, 1999. In the days that followed, law enforcement launched an intensive investigation. On September 9, 1999, Hanson and Miller were arrested at a local motel. Their arrest was initially for a separate crime, a robbery committed the day prior, on September 8, at a federal credit union. As police continued to investigate, they soon linked the two men to the murders of both Bowles and Thurman. Forensic analysis revealed their fingerprints on Bowles' vehicle, and investigators discovered a revolver, along with a 9mm semi-automatic pistol wrapped in plastic hidden inside the vehicle's gas tank. These were identified as the weapons used in the killings. The evidence led to formal charges against both men for the murders. Additionally, Hanson and Miller faced multiple federal robbery charges for crimes committed before and after the murders. George Hanson stood trial first. His criminal history included prior convictions dating from 1983 to 1990 for robbery and assault. In May 2001, he was tried separately for the first-degree murders of Gerald Thurman and Mary Bowles. After a nearly 5-hour deliberation, a jury in Tulsa County found him guilty of both murders on May 18, 2001. Prosecutor Tim Harris sought the death penalty in the case. A few days later, on May 23, the jury returned with their sentencing recommendations: the death penalty for Bowles' murder and life imprisonment without the possibility of parole for the murder of Thurman. Despite having received a death sentence, Hanson was not transferred to Oklahoma's death row. Instead, due to his involvement in separate federal robbery cases, he remained in federal custody. He was ultimately sentenced to life in prison for the federal charges and was housed at the United States Penitentiary in Pollock, Louisiana. Victor Miller, Hanson's accomplice, was tried separately following Hanson's trial. Miller had a violent criminal past as well. In 1981, he had been convicted of first-degree murder in another case and received a life sentence, along with 3 30-year terms for armed robbery, which were to be served concurrently. That earlier conviction was later reduced to second-degree murder, and Miller was released in 1997, just 2 years before the Bowles-Thurman murders. Like Hanson, he also faced federal charges for unrelated robberies and was sentenced to life in federal prison. He was then extradited back to Oklahoma to stand trial for the double homicide. On April 17, 2002, a separate Tulsa County jury found Miller guilty of both murders. 2 days later, on April 19, he was sentenced to death for Mary Bowles' murder and life without the possibility of parole for Gerald Thurman's. George Hanson's legal journey continued. On June 11, 2003, the Oklahoma Court of Criminal Appeals overturned his death sentence and ordered a resentencing trial. That new sentencing phase took place from January 9 to January 24, 2006, and once again, Hanson received the death penalty for the murder of Bowles. In April 2009, his appeal was dismissed. Appeals to higher courts followed, all of which were denied. The U.S. District Court for the Northern District of Oklahoma rejected his appeal in July 2013, the 10th Circuit Court of Appeals denied it on August 13, 2015, and the U.S. Supreme Court followed suit on May 16, 2016. Even as recently as September 10, 2021, another appeal was rejected. Hanson was one of 28 Oklahoma death row inmates who filed a lawsuit challenging the constitutionality of the state's execution procedures. However, in June 2022, the lawsuit was dismissed when the court ruled that Oklahoma's execution protocols did not violate constitutional protections. Meanwhile, Victor Miller pursued his own appeals. In 2004, the Oklahoma Court of Criminal Appeals overturned his convictions and sentences, granting him a new trial. That retrial took place in November 2008, during which he was again convicted on both counts of first-degree murder. This time, the jury recommended 2 death sentences. On December 9, 2008, Judge Dana Keown formally imposed both death sentences. However, Miller's legal saga did not end there. In 2013, the Oklahoma Court of Criminal Appeals heard his appeal and determined that one of his death sentences should be commuted to life without parole, while the other sentence should be overturned and subjected to another resentencing hearing. By November 2015, before the resentencing trial could proceed, Tulsa County prosecutors announced they would no longer pursue the death penalty in his case. As a result, Miller was handed a second life sentence without parole. As of 2025, he remains incarcerated at the Oklahoma State Reformatory. As Hanson exhausted all of his appeals by 2016, he remained on federal death row at USP Pollock. A 2020 report indicated he was one of 26 inmates in Oklahoma eligible for execution, having no remaining legal challenges. However, at that time, executions in the state were paused due to a series of mishandled executions, including a botched one in 2014 and 2 serious drug mix-ups in 2015. The state resumed executions in October 2021. On July 1, 2022, the Oklahoma Court of Criminal Appeals set execution dates for 25 death row inmates whose appeals had been exhausted. George Hanson's execution was initially scheduled for December 15, 2022, with a clemency hearing set for November 9 of the same year. Oklahoma officials requested the federal government to transfer Hanson to Oklahoma's custody to carry out the execution, but the request was denied. It was believed that this refusal may have been influenced by the Biden administration's moratorium on federal executions, although no official reason was confirmed. Subsequently, Oklahoma Attorney General John O'Connor filed a lawsuit against the Federal Bureau of Prisons for refusing to hand over Hanson. On December 13, 2022, U.S. District Judge Reed O'Connor ruled against the state, stating that the Bureau of Prisons had broad discretion in matters involving public interest and that the federal government could decline to authorize a transfer. As a result, Hanson's execution was indefinitely postponed. After Donald Trump was inaugurated as U.S. President on January 20, 2025, Oklahoma Attorney General Getner Drummond promptly reapplied for Hanson's transfer on January 23. The move was backed by an executive order signed by Trump directing the Department of Justice to resume capital punishment enforcement. Drummond criticized the prior administration's decision, calling it the epitome of subverting and obstructing the execution of a capital sentence. On February 13, 2025, newly appointed U.S. Attorney General Pam Bondi approved the request, allowing Hanson's transfer to proceed. By March 3, 2025, Hanson was moved to the Oklahoma State Penitentiary, the designated facility for housing death row inmates. On April 1, 2025, the Oklahoma Court of Criminal Appeals set his execution date for June 12, 2025. In the wake of this announcement, Jake Thurman, the son of Gerald Thurman, spoke publicly about the emotional weight of the long wait. He expressed a mix of relief and sorrow, stating that justice was finally being served after nearly 3 decades. He described his father as his hero and friend, adding that his children bore a strong resemblance to their grandfather, which kept his memory alive. Jake also shared how devastated he and his mother were when Hanson's execution was stayed in 2022. Tragically, his mother passed away less than 2 months later due to organ failure. Though he expressed disappointment that Miller had not received the death penalty, Jake also said he had made peace and forgiven both men. A clemency hearing was held for George Hanson on May 7, 2025. His legal team appealed for a commutation of his sentence to life without parole. Oklahoma Attorney General Drummond, however, strongly opposed any form of clemency. He urged the Pardon and Parole Board to reject the plea, stating, "This murderer's execution has been delayed for far too long. I am committed to ensuring that the Bowles family finally sees that justice is done for their loved one." On May 7, 2025, the Oklahoma Pardon and Parole Board, in a narrow 3-2 vote, officially denied the request for clemency. At 10:11 a.m., John Fitzgerald Hanson, 61, was declared dead after receiving a lethal injection of 3 drugs at the Oklahoma State Penitentiary in McAlester. At 10:01 a.m., the execution got underway. At 10:06 a.m., the doctor entered the execution chamber and declared him unconscious after the deadly medicines started to flow. Hanson could be heard snoring when the Department of Corrections Chief of Operations announced he was unconscious. For his final meal, he didn't ask for anything special. He did receive the same meals as the other prisoners: carrots, 2 rolls, 2 fruit cups, and chicken pot pie. His last words were, "Just forgive me. Peace to everyone." Stephen Stanko, June 13, South Carolina. Stephen Christopher Stanko, born on January 13, 1968, at the Guantanamo Bay Naval Base in Cuba, was convicted for a brutal series of crimes committed in 2005, which included the cold-blooded murders of 2 individuals, as well as the kidnapping and essay of a teenage girl, the daughter of one of his murder victims. Stanko's criminal background predates these murders. In 1996, he was incarcerated after being convicted of assault and kidnapping. He served 8.5 years of a 10-year sentence before being released from prison in 2004. During his time behind bars, he co-authored a book titled Living in Prison, A History of the Correctional System with an Insider's View. This work was written during his first prison stint and offered both a historical and personal account of the correctional system in the U.S. Upon release, Stanko was described by those who encountered him as an articulate, intelligent, and well-spoken former inmate. He appeared to be a reformed man who was open about his criminal past and often discussed the time he spent in prison, as well as the book he had written. He moved to Myrtle Beach, South Carolina, shortly after being released and rented a room where he stayed for nearly a year. His parole officer took measures to ensure transparency and confirmed that the landlady was aware of Stanko's criminal background, something Stanko himself disclosed when applying for the room. During this period, he kept a low profile. Although occasionally late with rent payments, he caused no significant trouble. He frequently lamented the difficulties he faced in securing stable employment due to his criminal record. Over the course of the year, he held 1 or 2 short-term jobs, though none lasted. Eventually, he vacated the rental property abruptly and moved in with a friend, offering to look after her elderly mother in exchange for room and board. Roughly 1 year after his release from prison, Stanko began spending time at a local library under the pretense of conducting research for a second book. It was during this time that he became acquainted with Laura Ling, a librarian who worked there. Their relationship grew, and eventually, Stanko moved in with Ling as her romantic partner. He also struck up what appeared to be a friendly rapport with another regular library patron, 74-year-old Henry Turner. However, beneath the surface of this seemingly stable post-prison life, Stanko was preparing for a spree of violence that would shock the community. In April 2005, he carried out a series of horrific acts. He strangled 43-year-old Laura Link to death, shot Henry Lee Turner in a fatal attack, and then essayed and violently attacked Link's teenage daughter by slitting her throat. Miraculously, the young girl survived her injuries and managed to place a 911 call that would lead to the unraveling of Stanko's crimes. Following a highly publicized trial where his defense team attempted to argue insanity, Stanko was convicted on multiple counts. On August 18, 2006, a jury in Georgetown County found him guilty of the murder of Laura Link and sentenced him to death. In addition, he received a prison sentence of 110 years for the related crimes committed against Link's daughter, included criminal sexual conduct, kidnapping, and armed robbery. In a separate trial in November 2009, related to the murder of Henry Turner, Stanko was again found guilty. This time, a jury in Horry County handed down a second death sentence. When law enforcement officers searched his residence, they discovered numerous articles and materials about infamous serial killers such as Jeffrey Dahmer and Gary Ritchie, the so-called Green River Killer. This led police to speculate that Stanko had either a strong interest in serial killers or was potentially attempting to become one himself. Following the brutal attacks, a nationwide manhunt ensued. A reward of $10,000 was offered for any information leading to Stanko's capture. Thanks to tips from the public, he was eventually located and apprehended without incident by the U.S. Marshals Service in Augusta, Georgia. At the time, Stanko had been hiding in the Augusta area, blending in during the annual Masters tournament, which attracts large crowds, making it easier for him to remain inconspicuous. Stanko's appeals process began on September 23, 2007, when he made his first appearance before the South Carolina Supreme Court. His legal team aimed to overturn the death penalty verdict he received for the murder of Laura Link. They argued that the original trial had been flawed, claiming the trial judge had improperly barred the defense from questioning prospective jurors about their views on the insanity defense. Moreover, they contended that the court did not permit them to present evidence about Stanko's age or mental state as mitigating or aggravating factors. Despite these arguments, the South Carolina Supreme Court ultimately upheld both the conviction and the sentence. Years later, in February 2013, Stanko suffered another legal defeat when the South Carolina Supreme Court affirmed his conviction and death sentence in the case of Henry Turner's murder. Following this, in 2015, Stanko sought post-conviction relief through another legal process known as a PCR hearing. During this proceeding, his former trial attorney, Bill Diggs, testified that Stanko suffered from a brain defect that may have influenced his behavior. Despite this testimony, on May 24, 2016, the court upheld the conviction and denied Stanko any form of relief. Stanko's final hope rested with the highest court in the country. However, on May 5, 2025, the United States Supreme Court denied his petition. According to 15th Circuit Solicitor Jimmy A. Richardson II, this denial meant that all legal appeals related to the murder of Henry Turner had been exhausted. As a result, the South Carolina Supreme Court was authorized to issue an execution notice. Execution notices in South Carolina are typically issued on Fridays in accordance with state procedures. This scheduling method ensures that the execution is carried out on the fourth Friday after the notice is issued, allowing adequate time for any last-minute legal interventions. In Stanko's case, the official notice of execution was issued on Friday, May 16, 2025, the first Friday available following the May 5th court decision. The preceding Friday, May 9, had been a state holiday, Confederate Memorial Day, during which the Supreme Court was closed. The execution of Stephen Stanko had been scheduled for June 13, 2025. He was given until May 30 to choose the method of his execution. Under current South Carolina law, death row inmates are permitted to select between three methods: electrocution, lethal injection, or a firing squad. Reacting to the long-awaited execution notice, the son of Henry Lee Turner expressed a sense of resolution. He publicly stated that he intended to be present for the execution and remarked that, in his opinion, it should have taken place many years ago. He remembered his father fondly, describing him as a cheerful, kind-hearted individual who was a loving and devoted parent. In the days following the announcement of his execution date, Stanko submitted a formal request to the state seeking more information regarding its protocols for both lethal injection and execution by firing squad. He initially indicated a preference for the firing squad. However, after reading published details about the recent execution of inmate Mikal Mahdi, he reconsidered. Ultimately, the South Carolina Supreme Court rejected his request for more information on May 29, 2025. On June 13, Stephen Stanko, 57, was pronounced dead at 6:34 p.m., following a farewell statement that lasted 3.5 minutes, during which Stanko apologized to his victims and requested that they not judge him based on the worst days of his life. The execution got underway. In contrast to earlier executions, witnesses could hear prison officials requesting the first dose of the sedative pentobarbital. Stanko seemed to be speaking as he turned to face the victims' families and then quickly exhaled as his lips trembled. After a minute, Stanko seemed to stop breathing. The color drained from his cheeks and hands, and his vibrant complexion vanished in an instant. 13 minutes later, a prison staff member requested a second dose of pentobarbital. About 28 minutes after the execution began, he was declared dead. Until long after Stanko's respiration ceased, 3 of the victims' relatives continued to stare at him. Stanko's lawyer and brother also observed. For his last meal, he chose fried fish, fried shrimp, crab cakes, a baked potato, carrots, fried okra, cherry pie, banana pudding, and sweet tea. His final words were, "Once I am gone, I hope that Christina, Laura's family, and Henry's family can all forgive me. The execution may help them. Forgiveness will heal them." Thomas Lee Gudinas, June 24, Florida. On the evening of May 23, 1994, Thomas Gudinas, along with 3 of his roommates, made their way to Barbella's bar located in Orlando, Florida. They arrived sometime between 8:30 and 9 p.m. Before reaching the bar, the group had already consumed alcohol and Mary Jane, drinking beer and smoking both at their shared apartment and again inside the car during their drive to the bar. Their substance use didn't stop there. Throughout the night, as they continued drinking, the group would periodically step outside to their vehicle to smoke some more Mary Jane. By the time the bar closed at 3 a.m., Gudinas was missing. One of his roommates later testified that the last time he saw him was around 1 a.m., but after that point, no one in the group knew where he had gone. That same night, Rochelle Smith and her fiancé also visited Barbella's, arriving between 11 and 11:30 p.m. After enjoying their time there, they decided to leave at approximately 2 a.m. However, Smith mistakenly walked to the wrong parking lot. It was there that she noticed a man crouched behind another vehicle, observing her. This man was later identified as Thomas Gudinas. Realizing her mistake, Smith walked over to the correct parking lot where her car was actually located, but she couldn't shake the feeling that someone was following her. Acting on instinct, she quickly got into her car and locked all the doors. Her fears were confirmed when the same man she had seen earlier suddenly approached her car. First, he tried to open the passenger side door. When that failed, he attempted to smash the driver's side window while shouting at her in a threatening and sexually aggressive manner, reportedly yelling, "I want to f*** you." Smith began sounding her car horn in a panic, which eventually caused Gudinas to flee the scene. Later on, she positively identified him from a police photo lineup as the man who had tried to assault her that night. The night took an even darker turn. Michelle McGrath was last seen alive at Barbella's at about 2:45 a.m. Like Smith, McGrath had parked in the same lot where Gudinas had been lurking earlier. Tragically, her body was discovered the next morning, on May 24, 1994, by an employee of Pace School located near the bar. Her lifeless body had been dumped in an alley adjacent to the school. The medical examiner estimated her time of death to be sometime between 3 and 5 a.m., indicating she died shortly after she was last seen. When her body was found, it was completely naked except for her bra, which had been pushed up above her chest. McGrath had suffered multiple severe injuries, including blunt force trauma to the head, and she showed clear signs of having been essayed. The medical team also found trauma to both the cervix and rectum, injuries that were caused by the forced insertion of foreign objects into her body. Additionally, genetic material was discovered both inside her private area and on her thigh, suggesting that sexual violence had occurred either before or after her death. The brutality she experienced was significant, marked by violent trauma, visible bite marks, and the kind of blunt force injury that suggested she had been stomped on. McGrath had been alive and conscious during large parts of the attack. Before the body was discovered, Jane Brand, an employee at Pace School, had noticed a suspicious man within the school's gated premises. When she confronted him and told him he needed to leave, The man quickly jumped over the fence and disappeared into the nearby alley. Curious and concerned, Brand looked into the alley and found Magratz's body. She later identified the man she had encountered on school grounds as none other than Thomas Gudinas. After Barbella's closed and everyone had returned to their apartment, all of Gudinas's roommates testified that he had not come back with them. Later, when they did see him again, they noticed what appeared to be fresh injuries, bloodstains on his underwear and scratches on his knuckles. When questioned about these wounds, Gudinas claimed that he had been in a physical altercation with two black men who had attempted to rob him. However, his story began to unravel. Two of his roommates testified that when asked whether Michelle Magrat had been a good fuck, Gudinas chillingly responded, "I killed her, then I fucked her." Gudinas's violent history extended well beyond this tragic incident. In the early 1990s, during his time as a juvenile, he had already racked up multiple felony convictions in the state of Massachusetts. His criminal record included charges such as burglary of a vehicle, assault, theft, assault with intent to essay, indecent assault and battery, and assault and battery. On Tuesday, June 24, Gudinas, 51 years old, was put to death by lethal injection. At 6:13 p.m., he was declared deceased. Media observers claimed that the sound of an air conditioner interfered with his final statements, making them inaudible. Gudinas uttered a prayer of some kind, according to a prison spokesperson. He had pizza, fries, and soda for his last meal. Richard Gerald Jordan, June 25, Mississippi. Jordan, born on May 25, 1946, was incarcerated on death row in the state of Mississippi, having been convicted for the brutal murder of 34-year-old Edwina Martyr in 1976. Edwina was the wife of Charles Chuck Martyr, a prominent bank executive. From 2022, Jordan held the distinction of being the oldest living inmate on Mississippi's death row, as well as the individual who has spent the longest duration under a death sentence in the state's history. At the time of the crime, Jordan was experiencing a severe financial crisis. Unemployed and facing mounting financial stress, he began contemplating a criminal plan to obtain money through unlawful means. His desperation led him to conceive a scheme in which he would target a wealthy individual, specifically a bank executive, with the intent of extorting ransom money. To carry out his plan, he contacted Gulf National Bank located in Gulfport, Mississippi, posing as someone seeking a commercial loan. Through this ruse, he was able to learn the name of the bank's commercial loan officer, Chuck Martyr. Once he had this information, Jordan located Martyr's residential address using a local telephone directory. He then drove to the residence and abducted Edwina Martyr. Tragically, instead of keeping her alive for ransom purposes, Jordan transported her to the DeSoto National Forest and fatally shot her. Following this, he called Chuck Martyr in an attempt to extort ransom money by falsely claiming that Edwina was still alive. Initially, Jordan was found guilty in 1976 and sentenced to death. However, that verdict and the corresponding death sentence were later overturned due to a landmark decision that deemed automatic death sentences unconstitutional. Jordan was retried in 1977 and once again convicted and sentenced to death. He later appealed this second sentence, raising constitutional objections, and as a result, he was again sentenced to death following another trial. When the third death sentence was also overturned on appeal, prosecutors offered Jordan a plea agreement. According to the terms of this deal, he would plead guilty in exchange for a sentence of life imprisonment without the possibility of parole, and in doing so, he would waive all future rights to appeal. Jordan accepted the terms of this plea bargain, but he subsequently violated the agreement by filing an appeal against his sentence. In his appeal, he argued that a sentence of life without parole was unconstitutional in his specific case because, at the time of the crime in 1976, Mississippi law did not provide for such a sentencing option. Instead, he sought to have his sentence reduced to life with the possibility of parole, which was an available punishment under Mississippi's sentencing laws at the time of his offense. While the courts ultimately found the original plea agreement to be invalid, they did not grant his request for parole eligibility. Instead, a new sentencing hearing was ordered. This hearing took place in 1998, and at the conclusion of that proceeding, Jordan was again sentenced to death. Richard Jordan was born in Hattiesburg, Mississippi, to Mr. and Mrs. Homer Jordan. He spent his childhood in the nearby town of Petal, Mississippi. People who knew him during his youth and school years would later describe him as someone with a generally good reputation. After completing his education at Bethel High School, Jordan enlisted in the U.S. Army, where he served for a period of 4 to 5 years, including active duty during the Vietnam War. By the mid-1970s, Jordan was married and the father of 3 children. Following his honorable discharge from military service, he found employment in Louisiana, while his wife and children remained in Hattiesburg. Jordan managed a fertilizer plant for about a year and also worked for a couple of months at a shipyard in Morgan City, Louisiana. By January of 1976, Jordan found himself in a state of dire financial distress. Faced with multiple debts and unable to make ends meet, he devised a desperate plan to kidnap a member of a wealthy family and demand ransom in exchange for their safe return. With this goal in mind, he set his sights on Gulfport, Mississippi, as the location where he would carry out his plan. On his way out of Louisiana, Jordan stopped at a pawn shop located at Baton Rouge, where he traded in his 16-gauge shotgun for a .38 caliber revolver. To his family, he lied, telling them that he was heading out to take a physical examination as part of the application process for a job of an offshore oil rig. Once in Gulfport, Jordan spent a few days familiarizing himself with the city and observing his surroundings. Then he set his plan into motion. On January 12, 1976, Jordan drove to the Martyr residence, where he posed as a utility worker from the electric company who needed to inspect the home's circuit breakers. Under this false pretense, he was able to convince Edwina Martyr to allow him access. He then abducted her from the home, leaving behind the couple's 3-year-old child, who was asleep inside. At the time of the abduction, Chuck Martyr was away at work and the couple's older son, who was 9 years old, was attending catechism class. After kidnapping Edwina, Jordan forced her to drive with him into the remote and heavily wooded DeSoto National Forest. At some point after exiting the vehicle, he shot her once in the head, killing her. Jordan claimed that he only fired his weapon after Edwina attempted to flee and that he had meant to fire a warning shot above her head. In contrast, the prosecution argued that the evidence, including forensic analysis, indicated that Edwina had been kneeling and was shot at close range. Following the murder, Jordan went to a local movie theater where he watched the film Death Wish, a vigilante crime drama. Afterwards, he contacted Chuck Martyr and demanded a ransom of $50,000, falsely asserting that Edwina was still alive. Later that evening, the two men spoke again and agreed on a specific location for the ransom drop. That night, Chuck Martyr went to the designated site with law enforcement officers discreetly following him. Jordan, who was observing the location from a distance in the DeSoto National Forest, immediately detected the police presence and suspected a setup. The next day, he called Martyr again, accused him of trying to trick him, and offered an alternative ransom plan, this time demanding only $25,000. He instructed Martyr to take a convoluted route to the drop site, making numerous turns before getting on the highway to shake off any possible police surveillance. On the morning of January 13, at approximately 9 a.m., Martyr left the cache at a predetermined location near the intersection of Interstate 10 and Canal Road in Gulfport. An FBI agent and a deputy from the Harrison County Sheriff's Office were stationed nearby, concealed in a pickup truck, waiting to apprehend Jordan. When Jordan arrived to retrieve the money, the officers sprang into action. Jordan rammed the sheriff's vehicle into a ditch and sped away, ignoring gunfire directed at his car. One of the deputies involved in this failed apprehension attempt was Larkin Smith, who would later rise to political prominence, serving as both the Harrison County Sheriff and eventually a U.S. congressman. Despite initially escaping the authorities and abandoning his car, Jordan was eventually located. Around 1 p.m. that same day, a Gulfport police officer spotted him inside the taxi. He was arrested without further incident, and the majority of the ransom money was recovered. During police questioning, Jordan confessed to having murdered Edwina and led authorities to both her body and the murder weapon. During a subsequent psychiatric evaluation, Jordan told a mental health professional he had not acted alone, that an accomplice had actually shot Edwina and fled the scene before Jordan attempted the ransom scheme. However, this account was inconsistent with earlier statements, and Jordan's defense team ultimately chose not to use it in court due to concerns over its reliability. In July 1976, Jordan stood trial for the crimes of kidnapping and capital murder. Due to the extensive media coverage and concerns about finding an unbiased jury in Harrison County, a change of venue was granted and the trial was moved to Jackson County. It took place in Pascagoula, with jury selection beginning on July 19. The trial lasted 3 days. The prosecution presented a total of 24 witnesses, while the defense chose not to call any. After 4 hours of deliberation, the jury returned a guilty verdict for capital murder on July 21. When asked by the judge whether he had anything to say before sentencing, Jordan declined to speak. At the time, Mississippi law mandated an automatic death sentence for capital murder convictions, and that was the sentence Jordan received. However, a case was already pending before the Mississippi Supreme Court that was widely expected to declare such automatic sentences unconstitutional. Anticipating this legal shift, District Attorney Albert Case and Assistant District Attorney Joe Sam Owen considered requesting a separate sentencing hearing, but found no legal basis under state law to support such a motion. That same year, the U.S. Supreme Court ruled that automatic death sentences did indeed violate the Eighth Amendment's prohibition against cruel and unusual punishment. As a result, Jordan was granted a new trial. His second trial began on February 28, 1977, again in Pascagoula. This time, the trial was bifurcated, with separate proceedings for determining guilt and, if necessary, sentencing. Jordan was once again convicted of murder on March 2, 1977. The sentencing phase took place on the same day. Defense attorney Earl Denham addressed the jury, stating that Jordan had been a good and decent man until around the age of 30, at which point something inexplicable changed in him. Denham described Jordan as mentally ill and incapable of understanding his actions. The defense presented several character witnesses, including Jordan's parents and a prison chaplain who had spent over a year praying with Jordan. The prosecution cross-examined the chaplain but called no new witnesses of their own. During deliberations, one juror initially opposed the death penalty. Denham and co-counsel Rhett Russell requested a mistrial, but the judge denied the motion. Eventually, the jury unanimously agreed to impose a death sentence. In the early 1980s, Jordan's attorneys challenged his sentence on the grounds that the jury had not received adequate instructions regarding how to determine whether aggravating circumstances applied. During closing arguments, Prosecutor Owen had told jurors that they had to individually decide what constituted an aggravating circumstance, without offering clear legal definitions. In 1982, the Fifth Circuit Court of Appeals ruled that the jury had not been properly instructed, citing a need for objective standards. The court overturned Jordan's sentence and ordered a new sentencing hearing. In the spring of 1983, shortly before this hearing, Denham withdrew from the case. Joseph Hudson, a Gulfport attorney, was appointed to represent Jordan, assisted by Earl Stegall. Although Owen had since moved into private practice, he agreed to serve as a special prosecutor for the hearing at the Martyr family's request. Jordan testified that he had been financially overwhelmed and desperate, owing money for a car, a boat, and several department store credit accounts. His defense team called witnesses to vouch for his character, including prison guards and family members. The prosecution presented forensic evidence suggesting Edwina was stationary when she was shot. They also introduced a recording of Jordan admitting that he had formulated the ransom plot before seeking legitimate employment. Once again, Jordan was sentenced to death. He would later challenge this third death sentence on the grounds that he was denied the opportunity to introduce mitigating evidence, specifically testimony from Rhett Russell about Jordan's good behavior in prison and the creative invention he had worked on involving wind tunnel-generated electricity. The Mississippi Supreme Court rejected this appeal, ruling the testimony to be inadmissible hearsay. However, the U.S. Supreme Court disagreed, reversed the sentence, and remanded the case for a new hearing. In 1991, prosecutors offered Jordan a plea deal to avoid a fourth sentencing trial. He would receive life without parole if he agreed never to challenge the sentence again. Jordan accepted. However, the resolution would not hold. Years later, Jordan filed a federal habeas corpus petition in which he challenged the legality of his sentence. He argued that life without parole was not a lawful sentence at the time of his crime in 1976 and therefore could not be applied retroactively to him. The federal court agreed, finding that the sentence was indeed unconstitutional in his case. Although the court did not grant Jordan's request to be resentenced to life with parole, it did vacate the sentence and return the case to the state for another resentencing. At this point, Mississippi prosecutors, frustrated by the repeated appeals and reversals, decided to pursue the death penalty once more. Jordan's legal team accused the state of prosecutorial vindictiveness, essentially punishing him for exercising his legal right to challenge his sentence. They contended that the prosecution had only sought the death penalty again as retaliation for Jordan's appeal in violation of his constitutional rights. The courts, however, ultimately ruled that there was no clear evidence of prosecutorial vindictiveness and allowed the state to proceed with seeking the death penalty. In April 1998, Jordan faced his fourth sentencing hearing. The trial was held in Harrison County. This time, the jury was given clear and constitutionally sound instructions regarding aggravating and mitigating circumstances. After considering the evidence, the jury returned yet another death sentence. Since that time, Jordan remained on Mississippi's death row, where he continued to pursue various legal appeals. He challenged both the constitutionality of his death sentence and the state's method of execution. One of his most recent and significant claims involved Mississippi's lethal injection protocol. Jordan's attorneys argued that the state's current execution method, which includes the use of midazolam, a sedative that has been the subject of multiple legal controversies, could result in severe pain and suffering, thus violating the Eighth Amendment's prohibition on cruel and unusual punishment. In addition to challenging the method of execution, Jordan repeatedly raised the issue of prosecutorial vindictiveness. Despite these arguments, the courts have consistently ruled against him. In 2022, Jordan became the oldest and longest-serving death row inmate in Mississippi. His case has been cited frequently by legal scholars and capital punishment critics as an example of the flaws and inconsistencies in the American death penalty system. Over nearly 5 decades, Jordan has been sentenced to death 4 separate times and has spent almost 50 years navigating the legal system. On June 25, he was executed by lethal injection. His last words were, "First, I would like to thank everyone for a humane way of doing this. I want to apologize to the victim's family. I will see you on the other side, all of you." Jordan was served his final meal of chicken tenders, French fries, strawberry ice cream, and a root beer float at 4 p.m. local time. How does a person spend their final day knowing there's no tomorrow? For 2 men in July, that day came, and it ended on a gurney. In this video, we'll talk about what they did to end up on death row, what their last words and last meals were. Mikal Bernard Bell, Florida, 30 years on death row. On December 9, 1993, Mikal Bell was given 2 death sentences for the murders of Jimmy West and Tamika Smith. Theodore Wright killed Mikal Bell's brother earlier in 1993. Wright said he shot in self-defense, which led to the incident being classified as justifiable murder. Bell pledged to his friends and family that he would kill Wright in retaliation for the death of his brother. On the evening of December 9, 1993, Bell saw Wright's car in the neighborhood. He went back to the area where he had first seen Wright's vehicle, gathering 2 of his pals and an AK-47 assault rifle he had bought the day before. Bell didn't know that Wright had sold the car to Jimmy West, his half-brother. Bell waited for West to leave the club after spotting the vehicle in the parking lot of a bar. After some time, West, Smith, and a third female started to leave the lounge and get into the vehicle. Bell entered the vehicle from the driver's side, unlocked the door, and opened fire from a close distance. Smith passed away from 4 bullet wounds on the way to the hospital, while West died instantly from 12 bullet wounds. The other female was able to duck to avoid being hit. Bell also opened fire at the spectators gathered outside the club before running to his aunt's house. In the past, Bell had other murder convictions as well. On September 25, 1989, Bell shot and killed LaShawn Cowart and her 2-year-old son Travis. The 3 were driving together when Bell stopped, exited the vehicle, and opened fire on the mother and son. Afterwards, an accomplice vehicle came and picked up Bell. On August 18, 1993, Bell shot and killed Michael Johnson, the boyfriend of Bell's mother. After the couple had an argument, Bell went to Johnson's house and shot him to death on the front porch. According to prison officials, on the day of his execution, Bell woke up at 6:30 a.m. and ate his final meal, which included an omelette, bacon, home fries, and orange juice. He spent time with a spiritual advisor but did not receive any other visitors. Strapped to a gurney, Bell remained alert and looked around the execution chamber as the lethal drugs were administered through his left arm. Within 2 minutes, he shut his eyes and became still. His breathing grew heavy for about a minute before slowing down. At 6:15 p.m., the team warden checked his eyes and called out his name, but there was no response. By 6:20 p.m., the color had begun to fade from his face. A medical professional entered the room at 6:24 p.m. and officially pronounced him dead 1 minute later. When asked if he had any final words, Bell replied, "Thank you for not letting me spend the rest of my life in prison." As the dust settled after Bell's execution, Florida prepared for a man whose crimes would haunt even seasoned investigators. Edward Zakrzewski, Florida, 28 years on death row. For the murders of his wife Sylvia, as well as his 2 children, Edward and Anna, Edward Zakrzewski was found guilty and given the death penalty. Zakrzewski and his wife were having marital issues before the killings. According to reports, Zakrzewski told a neighbor he would rather kill his entire family than go through with a divorce. At Glen Air Force Base, where Zakrzewski worked as a technical sergeant in the Air Force, his son Edward called him early on June 9, 1994, to let him know Sylvia was discussing wanting a divorce with family members. After that call, Zakrzewski went on his lunch break and bought a machete. He returned to work after making the transaction, working all day like nothing happened. Zakrzewski hid the machete in the bathroom when he got home earlier than the rest of his family that evening. He attacked Sylvia and rendered her helpless by hitting her twice in the head with a crowbar after his wife and kids arrived home. He brought her to their bedroom and used the crowbar to hit her in the head once again there. He then used a piece of rope to strangle her. Zakrzewski then called his son into the bathroom to brush his teeth. With the machete he had hidden behind the door, he assaulted Edward. The defensive wounds on Edward's arms and wrists showed that he tried to deflect some of the hits. The child's severe head, neck, and back traumas caused his death. After that, Zakrzewski summoned his daughter Anna into the bathroom, where he killed her with a machete as well. There is some disagreement regarding whether Anna was killed by Zakrzewski as soon as she entered the bathroom or whether he made her bend over the bathtub where her brother's body was lying before killing her in an execution-style manner. Anna's hands and arms also had signs of defensive wounds. He was not sure that he actually killed Sylvia, so after dragging his wife's body from their bedroom to the bathroom, Zakrzewski continued to beat her with a machete. According to reports, Sylvia suffered both blunt and sharp force injuries before eventually passing away. The lifeless bodies of Sylvia, Edward, and Anna were all placed in the bathtub, one on top of the other. When the police officers that were sent to do a wellness check the day after the killings entered the house, they were horrified when they discovered the murder scene. Sylvia was 34 years old, little Edward was 7 years old, and his sister Anna was only 5 years old. Following the killings, Zakrzewski drove to Orlando and booked a flight for Hawaii. He adopted a new name and settled down with a family who managed a spiritual commune in Hawaii. After the family he was staying with saw his image on Unsolved Mysteries, Zakrzewski turned himself in to Hawaiian authorities. What's interesting about this is that when the family saw his photo, Zakrzewski was right beside them in their living room. They joked about how the man in the picture resembled Zakrzewski, but he managed to convince them it was just a coincidence that they looked alike. The morning after, when the couple went to the shed where Zakrzewski was allowed to live on their property, he was already gone. On Thursday morning, Edward Zakrzewski woke up at 5:15 a.m. Later in the day, he ate a meal that included fried pork chops, root beer, and ice cream, according to a spokesperson for the State Department of Corrections. He also noted that Zakrzewski had one visitor and remained cooperative in the hours leading up to his execution. Covered with a white sheet, he was stretched out on the gurney. Right before the drugs were administered, he recited a poem as 14 witnesses, media representatives, and prison staff watched. As the lethal drugs took effect, Zakrzewski's breathing grew heavier. 3 corrections department officials in dark suits stood close by. One of them shook his shoulders and called out his name, but he didn't respond. Moments later, he was still. Edward Zakrzewski, 60 years old, was declared dead at 6:12 p.m. after receiving a 3-drug lethal injection at Florida State Prison in Stark. Since the death penalty was reinstated in the U.S. in 1976, Florida had matched its previous peak of 8 executions from 2014 earlier this year, a record that has now been surpassed with this latest execution. Zakrzewski's last words were, "I want to thank the good people of the Sunshine State for killing me in the most cold, calculated, clean, humane, efficient way possible. I have no complaint." Florida uses a 3-drug cocktail for its lethal injection, a sedative, a paralytic, and a drug that stops the heart. 7 victims lost their lives. 3 killers lost theirs in August 2025. Byron Black, Tennessee, August 5. The first death row inmate to be executed was Byron Black. The state of Tennessee resumed executions this year after a 5-year pause. Black was 32 years old when he committed the crimes for which he got the death penalty. Back in 1986, he was in a relationship with a woman named Angela Clay. She was 27. Angela was married to Benny Clay and they had 2 small daughters. Their marriage was not going well, so at the time Angela met Byron, she was separated from her husband but not officially divorced. In December the same year, Byron Black got into an argument with Benny Clay, and during that dispute he shot Angela's husband, wounding him in the shoulder. Because of this, Black was arrested and sentenced to 2 years in prison. His time in prison, though, was not as bad as you might think. At that time, prisons had certain programs in which the inmates with good behavior had the opportunity to work outside of the institution unsupervised, with the condition that they report back once their shift was over. In March 1988, Byron Black was part of such a program and he was on work release. He had already served the majority of his sentence and in a few months he was about to be set free. He contacted Angela, but according to reports, she made the decision to end things with Black because she was trying to rekindle the relationship with Benny, her husband. On March 28, 1988, Byron Black went to Angela's home. She was asleep when he entered her bedroom and shot her once in the head, killing her. Her 9-year-old daughter Latoya was right next to her, and Byron shot her in the neck and chest. He then went in the second bedroom where 6-year-old Lakeisha was, and he shot her as well in the chest and in the pelvic region. The investigation revealed that the little girl put up a fight and she really tried to defend herself, but the close-range shots ended her life. If Angela was in deep sleep and she probably didn't even realize Black had shot her, dying within just a couple of minutes, that was not the case with the 2 little girls. Latoya struggled for up to 10 minutes and Lakeisha for up to 30 minutes. After the murders, Black reported back to prison like he had done many times before. Meanwhile, the police was sent to Angela's house for a wellness check because her family was worried they couldn't get in touch with her or the kids. That's when the officers discovered the bodies. Black was a suspect from the start, but initially there was no evidence to link him to the murders. The authorities did manage to connect him to the crimes when they compared the bullets found at the house with the one that Benny had been shot with. Black used the same gun. He denied being the one who killed Angela, Latoya, and Lakeisha, saying he did go to the house and saw the bodies, but because he was afraid, he didn't say anything to anyone. The prosecution pursued the capital punishment, and in the end, Byron Black received 2 consecutive life sentences for the murders of Angela and 9-year-old Latoya, but he got the death penalty for the murder of 6-year-old Lakeisha. She had just turned 6 about 10 days before Black shot her. He actually got the guilty verdict on the day Lakeisha would have turned 7. Throughout the years, Black's lawyers tried to overturn his death sentence several times, but every time he ended right back on death row. He also had multiple death warrants signed and was about to be executed on multiple occasions, but he managed to avoid the lethal injection due to stays and reprieves. This year, however, his luck ran out. After 37 years, 69-year-old Byron Black was put to death by lethal injection. One controversy regarding his death was about his implanted defibrillation device. His attorneys tried to obtain a permit to have this device deactivated before the execution, fearing that during the protocol, his heart would be shocked multiple times in an attempt to restart it because of said device. He was ultimately denied the deactivation because that would have required a stay of the execution, which the courts were not willing to allow. For his last meal, he had pizza with mushrooms and sausage, donuts, and butter pecan ice cream. During the procedure, Black seemed to be in pain, at one point exclaiming, "It's hurting so bad." The cause of his apparent discomfort has not yet been determined. His attorney stated that they plan to examine the data recorded by the device as part of the autopsy review. Black refused to give an official last statement. During the 37 years he was on death row, he never once apologized for what he did. After spending decades behind bars before execution, do you believe the death penalty still serves its purpose in cases like this? If in Byron Black's case it took 37 years to carry out the execution, this next inmate spent 43 years on death row before he was finally put to death. Kayle Barrington Bates, Florida, August 19. Kayle Bates was not your typical killer. In fact, the crime he committed was inexplicable, and nothing pointed to the fact that he was capable of doing such a thing, nor he had any reason to. He was sentenced to death for the murder of 24-year-old Janet Renee White in 1982. She was abducted from the insurance office she was working at, a State Farm office. Kayle Bates had a somewhat normal childhood. His parents did have a troubled marriage, but they eventually got divorced and remarried. Kayle had a good relationship with both his biological parents and the step-parents he got along the way. He also got along very well with his sister and with his stepsister, the daughter of his father's new wife. Although he did not excel academically, he was always well-behaved and well-liked by pretty much everyone, his friends, his teachers, and his family. He joined the military after graduation, and he was regarded as a good soldier who followed orders, but he had some sort of cognitive limitations, which kind of got in the way of him being promoted. While in the army, he also worked as a truck delivery driver. He got married to his stepsister's friend from college and became a father. Again, this man was considered a good colleague, a great husband, and an incredible father. Sometime in 1982, he and his wife bought a new house because they were expecting their second child and needed more space. Kayle was hoping to get a promotion in the Florida National Guard, which he didn't get because he failed a test. Now, that would be the only reason the psychologists would think of when trying to identify the motive for his crimes, that he was under financial stress because he was not getting a pay raise, and he had a second child on the way after buying a new house. On the morning of the murder, Kayle had breakfast with his pregnant wife and his toddler. He even watered the lawn before leaving for work. Before noon, he stopped by the State Farm insurance office, where he had a brief conversation with Janet Renee White, then he left. Janet also left to have lunch at home with her husband, Randy. They had been together for 8 years, and they were very much in love. That weekend, they were together on a romantic getaway. Randy prepared a sandwich for Janet, and they ate while watching Days of Our Lives. They both went back to work after that, and he followed her to her workplace to make sure she got there safely. When Janet entered the office, the phone was ringing, so she managed to answer it, but right after that, she was attacked by Kayle Bates, who was waiting for her to return. The person on the other side of the phone heard commotion and horrible screams, so she notified the police. When the officers arrived at the scene, they noticed that there were signs of struggle in the office, and soon after, they spotted Kayle Bates exiting the woods nearby. He had dragged Janet to the woods where he tried to assay her, but wasn't able to, and then he stabbed her multiple times. He also stole the diamond ring she had on. Now, when the officers spotted Bates, he was covered in Janet's blood. They also found her body and the knife used to stab her soon after. Janet suffered 30 wounds in total. Bates denied killing her. He said he found her body in the woods while trying to get some cattails. He got scared and he fled. He then changed his account, saying he also saw a white male that was hitting Janet. Forensic testing, however, uncovered the evidence. There was genetic material that belonged to Bates on Janet's underwear from the attempted assay. After being sentenced to death, Kayle Bates reverted back to his good behavior and old self. Nobody understands to this day what happened to him that he was capable of committing such a terrible act. Janet's husband attended the execution. 67-year-old Kayle Bates was executed by lethal injection. He declined the final special meal and he didn't have any last words. If given the choice, would you have sentenced Bates to death or life without parole? I mean, I'm not sure I agree with the capital punishment for Bates, considering he did not live a life of crime before the killing, and he was regarded as a good person in general. Curtis Windom, Florida, August 28. The third inmate executed in August was from Florida as well. Curtis Windom spent 33 years on death row before facing execution for the 3 murders he committed back in 1992. On the morning of February 7, 1992, Curtis Windom learned that Johnny Lee, a friend who owed him nearly $2,000, had won about $100 at the dog track. After hearing this from his friend Jack Luckett, Windom made it clear that he intended to kill Lee, even telling Luckett that he would soon see it on the news. The money debt was not the only thing troubling Curtis Windom. He had been in an on-again, off-again relationship with Valerie Davis. There was a rumor that his friend Johnny was somehow romantically involved with Valerie behind his back. Later that same day, Windom bought a .38 caliber revolver at Walmart, a purchase confirmed by the receipt. The store clerk who sold him the gun later recalled that Windom appeared calm as could be. Armed with the revolver, Windom tracked down Lee, who was standing beside the road speaking with 2 women. Their common friend Luckett was also there. Windom drove up, shot Lee twice in the back, and then stepped out of his car to fire 2 more shots at close range. After killing Lee, Windom headed to the apartment complex where his girlfriend, Valerie Davis, lived with her mother, Mary Lubin. Windom, who shared a child with Davis, also used to live there. At the time, Davis's friend Cassandra Hall had just arrived and witnessed Windom shoot Davis in the chest without any provocation, killing her instantly. As Windom fled the apartment, he crossed paths with Kenneth Williams and shot him at close range in the chest. Williams survived the attack and later testified that Windom looked abnormal and visibly disturbed just before pulling the trigger. Williams required 30 days of hospitalization. Windom then ran behind Brown's bar, where several of his friends, including his own brother, attempted to take the gun away from him, but they couldn't do it. Meanwhile, Mary Lubin, Valerie Davis's mother, had learned her daughter had been shot and was on her way home. As she stopped at a nearby intersection, Windom approached her vehicle, said something to her, and then shot her twice, killing her. Curtis Windom was later convicted of 3 counts of first-degree murder and 1 count of attempted first-degree murder. The child Windom had with Valerie Davis was a daughter named Curtisia. Over the years, she came to forgive her father for murdering her mother and grandmother. She was only 9 months old when her father took her mother from her. Curtisia pleaded for her father's life, arguing that if she was able to forgive him for what he did that impacted her life so much, no stranger should have a say in the matter. When the curtain to the execution chamber opened, Windom's face was covered with a sheet. Moments later, he received a lethal injection made up of 3 drugs. In his final words, he mumbled something about being on death row, though it was not clearly understood. As the injection began, he took several deep breaths, his legs twitched briefly, and then his body became motionless. Windom's last meal was ribs, baked beans, collard greens, potato salad, pie, ice cream, and a soda. Windom showed no hesitation in carrying out multiple murders. Do you think people like him should face quicker executions? September saw the end of several lives behind prison walls, each case a story of crime, consequence, and controversy. Today we look at the people executed this month and the details that led them there. David Joseph Pittman, Florida, September 17. Pittman was found guilty and sentenced to death for the brutal murders of Clarence, Barbara, and their daughter Bonnie Knowles. Clarence and Barbara's other daughter, Marie, had been married to Pittman, but their marriage had fallen apart and she had filed for divorce. Pittman opposed the separation, and throughout the proceedings, he repeatedly threatened Marie as well as members of her family. In the early hours of May 15, 1990, several witnesses contacted the fire department to report flames coming from the home of Clarence and Barbara Knowles, Marie's parents. Investigators later determined that before setting the fire, the intruder had cut the house's phone line, making it impossible to call for help. Afterward, he fled the scene in a car belonging to Bonnie Knowles, the couple's other daughter. When firefighters extinguished the blaze, the bodies of Clarence, 60, Barbara, 50, and Bonnie, 21, were discovered inside. All three victims had been viciously stabbed multiple times, with the official cause of death listed as severe blood loss. In Bonnie's case, the attack was even more gruesome. Her throat had been slashed. On that same morning, a witness reported seeing a vehicle resembling Bonnie Knowles's abandoned in a roadside ditch near the family home. He then observed a truck, later confirmed to belong to Pittman, pulling up beside the stranded car. Shortly after, the car was engulfed in flames. Another bystander recalled spotting a man fleeing from the burning vehicle. When later presented with a photo lineup, this witness identified Pittman as the man he had seen. The case against him was further strengthened by the testimony of a jailhouse informant who stated that Pittman had openly confessed to committing the murders. In Florida, executions are carried out using a three-drug protocol, first a sedative, then a paralytic, and finally a drug designated to stop the heart, according to the state's Department of Correction. On the day of his execution, David Pittman, 63, was put to death at Florida State Prison in Stark under a death warrant authorized by Republican Governor Ron DeSantis. He was officially pronounced dead at 6:12 p.m. As the chemicals entered his system, witnesses observed Pittman take several deep breaths before his body went motionless. His last words were, "I know you all came to watch an innocent man be murdered by the state of Florida. I am innocent. I didn't kill anybody. That's it." His last meal was steak, chicken, and biscuits.
The sentence of the state of Florida v. David Joseph Pittman was carried out at 6:12 p.m. on September 17th, 2025. The execution took place without incident.
Capital punishment does not reduce murder, but it sure reduces the opportunity for future murder.
Geoffrey Todd West, Alabama, September 25. West was found guilty of capital murder in the death of 33-year-old Margaret Parrish Berry. On the night of March 27, 1997, West and his girlfriend drove to Harold's Chevron, a convenience store located at 2920 Nokalula Parkway, where West had once been employed. Before the incident, he had openly talked about his plans to rob the store and eliminate any witnesses, even saying he would kill the person up there. Armed with a .45 caliber handgun, West entered the Chevron. Evidence suggests that he held Berry, the store attendant, at gunpoint and stole approximately $250 from a cookie tin used as the store's cash box. Medical findings later revealed that Berry had been shot in the back of the head while lying face down behind the store counter. The medical examiner testified that such a wound would have caused almost immediate incapacitation and a very swift death. At the age of 50, Geoffrey Todd West was put to death at William C. Holman Correctional Facility through the use of nitrogen gas, a method of execution Alabama first implemented just last year. His execution was one of two carried out in the U.S. on the same night. In Texas, authorities also executed a man convicted of murdering his girlfriend's 13-month-old baby daughter. When the warden asked if he had any last words, West simply responded, "No, sir." Secured to the gurney with a blue-rimmed gas mask strapped to his face, he signaled a thumbs up toward his attorney as the execution process began at approximately 5:56 p.m. Throughout the first 2 minutes, his eyes remained open as he appeared to gasp and fight for air. His head shifted from side to side, his left hand clenched into a fist, and faint foam gathered at his mouth. By around 6:01, his breathing pattern changed, becoming a sequence of long, drawn-out breaths separated by extended pauses. Roughly 6 minutes later, at 6:07, he became motionless. The official time of death was recorded at 6:22 p.m. In a final statement shared through his attorney, West expressed that he had already offered a private apology to the family of Margaret Parrish Berry and said he was deeply humbled by the forgiveness shown to him by her son, Will. He went on to share that earlier this year he had been baptized into the Catholic Church and that he now felt at peace, confident that he knew where he was going after death. West was executed using a method that involved securing a gas mask over his face and exposing him to pure nitrogen gas, which deprived his body of oxygen. Regarding West's movements during the execution, Corrections Commissioner John Hamm stated that he believed most of them were involuntary and that the procedure unfolded exactly as expected under protocol. On the day he was executed, 50-year-old West met with his family, attorneys, and spiritual advisor, as recorded in the corrections log. He consumed coffee and Coca-Cola, had a sausage biscuit and some Skittles, and his last meal consisted of chicken quesadillas. Blaine Keith Millam, Texas, September 25. On December 2, 2008, 18-year-old Millam contacted law enforcement to report that he had discovered the body of his girlfriend's 13-month-old daughter, Amora Carson.
Rescue 911.
My name's Blaine Millam, and my daughter, I just found her dead.
How old's your daughter?
13 months.
13 months old? Okay, let me connect you with the ambulance service, okay? Ma'am, we're going to try CPR anyway, okay? Get her to the phone now.
51 minutes, 26 seconds.
Dinner! Blaine, dinner, hurry! Are you there? Yes. Y'all stalling is not helping her at all. If he's not going to do it, you put the phone down and go get that baby and get her to the phone.
At the time, Millam was engaged to Amora's mother, Jessica Carson, and the couple lived together in a trailer in Rusk County, Texas. When authorities arrived, they found Amora's body displaying severe injuries, including multiple bite marks and fractured ribs.
I'll never forget the bite marks. From the toe to the chin to over the mouth and nose. It was almost as if someone was trying to, suck out demons from the nose and mouth, the way the bite mark or the mouth print was on the child. I've never seen anything like it in my life.
Initially, both Millam and Jessica told police that they had left Amora alone for roughly an hour before returning to find her dead. Later, their account changed dramatically. They claimed that Amora had been possessed by demons and that they had attempted an exorcism on her.
Tell me what happened.
I could tell you, but you wouldn't believe me.
I will. I will believe you.
No, you won't.
I will believe you. I promise.
If you do, none of the other cops won't.
A follow-up autopsy revealed that both Millam and Jessica had bitten Amora and struck her with a hammer during their attempted exorcism. The little girl also had been assayed. In 2010, Millam received a death sentence. Despite his conviction, he continued to assert his innocence, blaming Jessica for Amora's death and for introducing the story of demonic possession. Subsequently, his legal team challenged the death sentence, arguing that it relied on unreliable forensic bite mark evidence and claiming that Millam was intellectually disabled, making him ineligible for execution under constitutional law. Millam's execution had previously been postponed in both 2019 and 2021 to allow time for him to appeal his conviction and death sentence. However, these appeals were ultimately unsuccessful, and he was determined to be mentally competent for execution. On his scheduled execution date, the U.S. Supreme Court denied his request for a stay. Later that same day, Millam was executed by lethal injection at the Huntsville unit in Huntsville, Texas. In his final statement, Millam expressed appreciation to the Texas Department of Criminal Justice for allowing death row inmates access to the prison chaplaincy program. His last words were, "If any of you would like to see me again, I implore all of you, no matter who you are, to accept Jesus Christ as your Lord and Savior, and we will meet again. I love you all. Bring me home, Jesus." Texas doesn't offer a final special last meal, but we do know that Millam was offered what the other inmates were given that day, so his actual final meal comprised a cheeseburger, oven-fried potatoes, green beans, pinto beans, sliced bread, scrambled eggs, country gravy, a sausage patty, pears, biscuits, tea, and water. Victor Tony Jones, Florida, September 30. On December 19, 1990, the bodies of 66-year-old Matilda Nestor and 67-year-old Jacob Nestor were discovered at their place of business. Victor Tony Jones, who had recently started working at the business, was found collapsed on a couch in the main office, a .22 caliber automatic pistol lying beneath his arm. Matilda Nestor was located in the bathroom with a stab wound to her back, while Jacob Nestor was found in the main office suffering from a stab wound to the chest. Evidence indicated that Jones had stabbed Matilda as she was entering the bathroom, and he attacked Jacob as he approached from the main office. After being stabbed, Jacob retreated to the main office where he attempted to call for help. He then drew his own .22 caliber pistol and fired at Jones 5 times, striking him once in the forehead. Additionally, the personal property and money belonging to the Nestors were found in Jones's pockets. Police, alerted by a neighbor, arrived at the scene and found Jones. When questioned about the incident, he stated, "The old man shot me." Later, at the hospital, Jones told the nurse he had to leave because he had killed those people. When asked for the reason, he replied, "They owed me money and I had to kill them." Jacob had hired Jones to help him that day because he knew the man needed money. When Jones asked to be paid before he completed the job, Matilda refused to give him the money, so he killed the couple out of spite. The Nestors had a daughter and a son. Their son later became a 9/11 hero, working in law enforcement when the tragedy happened. He carried the woman to safety just before the towers collapsed. Unfortunately, he passed away in 2020 of cancer, which the medical professionals believe he developed because of what he had inhaled that day. The daughter of the couple as well as their granddaughter wanted to attend the execution so that they'd be able to put all of the suffering behind them. On the morning of his execution, Victor Tony Jones woke up at 4:30 a.m. He spent part of the day with a spiritual advisor, his only visitor, and officials noted that he remained calm and cooperative throughout. For his final meal, he requested a simple southern plate, fried chicken, collard greens, and sweet tea. As evening fell, the prison prepared for his execution. 64-year-old Victor Tony Jones was pronounced dead at 6:13 p.m. after receiving a lethal injection inside Florida State Prison near Stark. His death marked another entry in Florida's record-setting year for executions, with officials already preparing to carry out 2 more the following month. At exactly 6 p.m., the curtain to the viewing room was drawn back, signaling the beginning of the procedure. When asked if he wished to make a final statement, Jones simply replied, "No, sir." Moments later, the lethal drugs began coursing through his veins. His chest rose and fell sharply at first, each breath labored, before gradually slowing until it stopped entirely. Several minutes into the execution, the warden called out Jones's name and shook him, but there was no response. His skin began to pale as he lay motionless on the gurney. Eventually, a prison medic entered the chamber, checked him, and officially declared him dead. According to prison officials, the execution proceeded without complications. In October, 7 death row inmates across the United States were executed. From the crimes that sealed their fate to their last meals and final words, here's a look at every execution carried out this month. Roy Lee Ward, October 10, Indiana. On the morning of July 11, 2001, in Dale, Indiana, 16-year-old Stacy Payne was at home preparing to leave for work while her younger sister Melissa slept. Ward approached the house pretending to look for a lost puppy and convinced Stacy to let him in after observing the family leave for work. Shortly after, Melissa awoke to screams and saw Ward on top of Stacy from the stairs. Terrified, she ran to her parents' room, locked the door, and called 911, hearing her sister plead with Ward and him telling Stacy to be quiet. The Daletown marshal arrived shortly after and found Ward standing in the doorway, sweating and holding a knife. The marshal drew his service revolver and ordered Ward to the ground, which he obeyed, claiming, "I didn't do anything." Upon checking the kitchen, the marshal discovered Stacy lying on the floor, naked from the waist down, flailing her arms and legs in an attempt to communicate. Ward had inflicted horrific injuries: a 24-inch cut across her abdomen, slashing her throat and severing her windpipe, and right internal jugular vein, leaving her backbone exposed. A doctor determined that Ward had sliced through the front of Stacy's abdomen, driving the knife all the way through her midsection into her spine. Despite the severe trauma, Stacy survived the attack and remained alive during EMT treatment at the scene, even holding an ER nurse's hand when asked if she understood what was happening. EMTs reported that she was conscious and resisted help out of fear that Ward would return. The attack lasted approximately 10 minutes, and it took 44 minutes to arrive at the hospital for her to receive any pain medication. After receiving 46 minutes of care at the initial hospital, Stacy was airlifted to the University of Louisville Hospital, where she was pronounced dead. The autopsy revealed she also suffered 18 blunt force injuries and ligature marks on her right forearm and left shin. During this horrific attack, Ward also essayed her. Experts have concluded that Ward was a psychopath, showing no empathy or moral conscience. His mother, grandmother, and other relatives believed he had to spend the rest of his life in prison. Even his own attorneys recommended that jurors sentence him to life without parole, citing his extreme danger to society. Ward's lawyers spent 2 decades unsuccessfully trying to overturn his death sentence, including a recent failed attempt to challenge Indiana's lethal injection protocol. Stacy Payne was an honor student in her first year at Heritage Hills High School, ranking among the top 10 in her class. She had been active in student council and cheerleading and received recognitions such as the Patriot Student of the Month. Stacy was involved in her youth club in St. Joseph Catholic Church and was working her first job that summer, saving money for her future. Ward had a long criminal history spanning over a decade, including sexual offenses and sporadic burglaries. Reports indicate he would commit acts of indecency during deliveries, such as ordering flowers or pizza to expose himself to the delivery person. At the time of Stacy's murder, he was on probation for a Missouri burglary and had multiple charges of public indecency. Ward's last meal was from Texas Squirrel and consisted of the following: 1 hamburger, 1 steak melt, 1 order of French fries, 1 baked potato with butter, 1 order of 12 fried shrimp, 1 sweet potato, 1 order of chicken Alfredo, and 1 order of breadsticks. Ward's last words were, "Brian is going to read them." Indiana is one of only 2 states out of the 27 that have the death penalty that prohibit media from witnessing executions. For Ward's execution, his witnesses were limited to attorneys and spiritual advisors. Just days later, in another part of the country, a different execution took place, one that would also draw public attention for its chilling details. Lance Shockley, October 14, Missouri. On the night of November 26, 2004, Lance Colin Shockley and Jeffrey Bayless, engaged to Shockley's sister-in-law, were in Bayless' pickup near Van Buren, Missouri, when they crashed. Bayless died in the accident, while Shockley survived but fled the scene. Sergeant Carl Dwayne Graham Jr. led the investigation, which quickly focused on Shockley as a suspect. Authorities found beer cans and a tequila bottle in the truck, indicating possible alcohol use, and noticed blood smeared above the passenger side wheel. On March 20, 2005, Sergeant Carl Dwayne Graham Jr., a 12-year veteran of the Missouri State Highway Patrol, was ambushed and shot by Lance Colin Shockley as he returned home from his patrol shift. Shockley, previously under investigation for the fatal crash that killed Jeffrey Bayless, likely attacked Graham to hold the investigation and avoid accountability, as Graham had already identified him as the primary suspect in the involuntary manslaughter case. The autopsy of Sergeant Graham revealed the severity of the attack. He was shot multiple times, including a bullet from behind that struck his neck and severed his spinal cord, instantly incapacitating him. Additional shots hit his face and shoulder. As he collapsed to the ground, the fall caused further injuries, including fractures to his skull and ribs from striking the pavement. Just 3 days after Sergeant Graham's murder, on March 23, 2005, authorities arrested Lance Colin Shockley for the earlier hit-and-run that killed Jeffrey Bayless. Investigators quickly linked him to Graham's shooting as well, leading to Shockley's formal arrest for both the fatal crash and the deliberate murder of the patrol officer. Lance Shockley, 48 years old, was executed by lethal injection at the state prison in Bonne Terre and pronounced dead at 6:13 p.m. During the execution, his head was propped on a pillow, and he lifted it to communicate with loved ones in the witness room. A woman attempted a detailed conversation with him through the soundproof barrier, which stopped after about 90 seconds when he laid his head back. 7 witnesses observed Shockley, while there were 12 for Graham and 13 for the state. Some witnesses showed emotion, wiping tears, while most had no visible emotions on their faces. On the morning of his execution, Shockley was visited by his daughters and a friend before being led to the death chamber. His last meal was peanut butter, 3 packs of oatmeal, water, and 2 sports drinks. His final words were written down before the execution, and he said, "So also you have sorrow now, but I will see you again, and your heart will rejoice, and no one will take your joy from you." While that chapter closed in one state, another was unfolding elsewhere. Let's move to Florida, where the authorities executed a man in the same day. Samuel Lee Smithers, October 14, Florida. Smithers was convicted and sentenced to death for the murders of Christy Cowan and Denise Roach. His connection to the Whitehurst property began in 1995 when he agreed with Marion Whitehurst, whom he knew from church, to maintain the lawn at her vacant 27-acre home in Plant City. Whitehurst gave him a key to the property gate, but not the house. He continued this arrangement into 1996. On May 28, 1996, Whitehurst visited the property and saw Smithers cleaning an axe on the carport. She also noticed a pool of blood, which Smithers casually dismissed as animal-related. Concerned, Whitehurst called the sheriff's department. When a deputy arrived that evening, the blood was gone, but drag marks led from the carport to a pond. Investigating further, authorities found Christy Cowan's body floating in that pond. A dive team later recovered a second victim, Denise Roach, from the same pond, confirming the horrific crime. After the murders, police conducted a thorough search of the Whitehurst property, uncovering key evidence linking Smithers to the crimes. They found a condom wrapper and a semen stain in a bedroom, suggesting sexual activity connected to the murders. Smithers' fingerprint was located in the kitchen, and forensic testing confirmed that the blood on the carport matched Denise Roach's DNA, establishing a direct connection to the victims. Additional evidence reinforced the case. Security camera footage from a convenience store captured Smithers with Christy Cowan on the day of her murder, placing him with her at a critical time. Investigators also determined that both Cowan and Roach were engaged in sex work in the area, and Bonnie Cruz, a local sex worker, identified Smithers as a previous client, further linking him to the victims. Smithers claimed that on May 7, 1996, he was mowing the lawn at the Whitehurst property when Denise Roach approached him, stating she had permission to be there. By May 13, she was still on the premises, despite his efforts to get her to leave. According to Smithers, a confrontation ensued in which Roach hit him on the arm and he struck her in the face in retaliation. The conflict escalated when Roach threw a planter at his truck. During the altercation, Smithers shoved her against the wall, causing a piece of wood to fall and strike her head, rendering her unconscious. He then left the property but returned the next day to move her body to the pond on the estate. Smithers gave a separate account of Christy Cowan's murder, claiming he had stopped to help a car parked on the roadside, which was driven by Cowan. He said he offered her a ride to a nearby convenience store, but Cowan allegedly demanded money and threatened to accuse him of SA if he didn't comply. Smithers stated that he drove her to the Whitehurst property, gave her all the money he had, but she became upset and threw a drink at him. In response, he claimed he struck her in the head with an axe, rendering her unconscious, and then dragged her body to the pond on the property. Smithers stated that while he was cleaning the axe on the carport, Marion Whitehurst arrived at the property. He claimed he could hear Cowan making noises in the background during this encounter, indicating she was still alive at the time. After Whitehurst left, Smithers said he returned to Cowan, struck her in the head again to silence her, further contributing to the violent sequence that led to her death. Smithers, now 72, was executed by lethal injection at Florida State Prison near Stark and pronounced dead at 6:15 p.m. At the scheduled 6 p.m. start, he was already strapped to the table with an IV in place. When asked for a final statement, he declined. During the procedure, his breathing was initially heavy and he experienced slight convulsions before all movement ceased. A warden attempted to call him without success and his complexion turned gray. A medic checked his vital signs at 6:14 p.m. and he was declared dead 1 minute later. Smithers' last meal was fried chicken, fried fish, a baked potato, apple pie with vanilla ice cream, and a sweet tea. Meanwhile, in a different state, preparations were underway for yet another execution, just a day after Smithers faced his punishment. Charles Ray Crawford, October 15, Mississippi. On January 29, 1993, Christy Ray, 20 years old, visited the bank where her mother worked before leaving with her around 5:15 p.m. They planned to meet later at home in Chellybeat, Mississippi. By 6:45 p.m., her mother's attempts to call Christy went unanswered, and when she arrived home around 7 p.m., Christy's car was missing. Inside the house, Mary found a ransom note with a hand-drawn map demanding $15,000 in a gym bag, warning no police or Christy would die. Christy's purse was left behind, her bedroom was disturbed, and the phone was out of service. After discovering Christy was missing, Mary drove around Walnut, checking her daughter's boyfriend Brian Mathis's home and the video store where Christy worked, but found no signs of her. She called her husband Tommy and then 911 to report the disappearance. Returning home, Mary noticed signs of a break-in. Christy's window screen had been cut and a pallet was propped against the house, and someone had rifled through a drawer in her parents' bedroom. On the same day, Charles Crawford's family found a similar ransom note in their attic. Concerned because Crawford was due to stand trial for assault and rape, his family gave the note to his attorney, William Fortier, who informed authorities investigating Christy's disappearance. The Saturday after Christy's disappearance, authorities established a command post at Charlie Beach School and stationed officers at the home of Crawford's former father-in-law, where Crawford had been seen. When Crawford returned to that location, he was arrested while carrying a double-barrel shotgun and a switchblade. When Crawford arrived at the command center, he was handed to FBI agent Joseph Jackson. He first said he had been hunting, but broke down and admitted Christy was dead when asked if she was still alive. Crawford then agreed to lead authorities to her body. He guided the team through dense woods at a site roughly 400 yards from the abandoned Hopper barn, where Christy's body was found at 9:48 p.m. Her hands were cuffed behind her, a sock and gag secured her mouth, her jeans pulled down, and she was not blindfolded. Dr. Stephen Hain, the pathologist who conducted Christy's autopsy, determined that she had been killed by a single stab wound to the chest. In addition to this fatal injury, her body bore numerous abrasions on both legs, as well as scrapes across her back and buttocks. She also had bruises and abrasions on her face and chest, contusions on her lips, and marks on her wrists that were consistent with being restrained by handcuffs. Hain explained that the abrasions on Christy's thighs and buttocks had occurred while she was still alive, suggesting she had struggled or been dragged across a rough surface such as branches or twigs. These injuries were typical of those seen in victims attempting to resist an essay. The facial abrasions and bruising around her lips indicated that her face had been pressed forcefully against a hard surface. The stab wound to the left side of her chest penetrated both her heart and left lung, causing massive internal and external bleeding. Hain estimated that it would have taken between 1 or 2 minutes for her to die. The wound was consistent with a Marine Corps-style K-bar knife. Crawford told the FBI that on January 29, 1993, his mother dropped him off near the Hopper barn so he could go hunting. He carried a shotgun, revolver, and knife and said he had been storing food there for weeks. Feeling anxious and depressed, he claimed he blacked out and later woke up inside Christy Ray's house, where she was already handcuffed and crying. He said he wore a ski mask so she couldn't identify him, asked for her car keys, and took her with him, denying any knowledge of the ransom note. According to Crawford, Christy calmed down while they drove and they talked. He later removed her handcuffs after she promised not to run and took her to the Hopper barn to spend the night. Crawford said that they talked and shared food until morning when he heard sirens nearby. Christy urged him to surrender, saying no one had been harmed. He said he decided to let her go, removed his mask, and gave her his shotgun, but claimed he blacked out again at that moment. He said that after his second blackout, he found himself sitting on a stump in the woods, barefoot and disoriented, with Christy lying dead at his feet, still handcuffed behind her back. He said she was fully clothed but had one of his socks in her mouth. Crawford admitted to dragging her body by the feet to hide it, which he said caused her clothing to shift. He covered her with leaves to conceal her remains and sat nearby for a while, trying to decide what to do next. Crawford said he then headed toward his former father-in-law's house, where he was eventually arrested. He told investigators that he knew taking Christy was wrong, but initially denied involvement because he needed time to think. Crawford admitted he must have killed her, but insisted he didn't remember doing it, claiming he suffered from uncontrollable blackouts. Crawford spent more than 30 years on death row. In addition to Christy Ray's kidnapping and murder, he was convicted in separate cases of attacking 2 other women, one of whom he struck in the head with a hammer, and another, a 17-year-old girl, whom he essayed. Both victims had been friends and were together at the time of the assault. In each of these trials, Crawford maintained the same defense he later used in Christy's case, claiming that he suffered from blackouts and had no memory of committing the crimes. Charles Crawford, now 59 years old, was executed by lethal injection at the Mississippi State Penitentiary in Parchman and pronounced dead at 6:15 p.m. The procedure began at 6:01 p.m., during which Crawford was observed taking deep breaths. About 5 minutes later, he appeared to lose consciousness. By 6:08 p.m., his breathing had slowed and became shallow, with a slight quiver of his mouth. 1 minute later, he took a final deep breath before his chest stopped moving entirely. His last words were, "To my family, I love you. I'm at peace. I've got God's peace. I'll be in heaven." His last meal was a double cheeseburger, French fries, peach cobbler, and chocolate ice cream. October showed no sign of mercy. Only days after this execution, another inmate was led to the chamber. Richard Jerf, October 17, Arizona. Richard Kenneth Jerf, later convicted on 4 counts of first-degree murder and sentenced to death on May 22, 1996, had once befriended Albert Luna Jr. while both worked night shifts as custodians at a Safeway. In January 1993, Luna broke into Jerf's apartment and stole numerous items: a TV, a VCR, stereo gear, car alarm, and even an AK-47. Jerf reported the theft to Glendale police, who took no action. His anger and frustration built over the following months and turned into a plan for revenge. On the morning of September 14, 1993, Jerf went to the Luna home, prepared to attack. He carried a 9mm Beretta, a knife, latex gloves, handcuffs, red fuse cord, and used a vase of artificial flowers as a pretext to gain entry. When Patricia Luna answered, Jerf forced his way in, brandishing the gun, and bound her in the master bedroom while letting her 5-year-old son Damien move about. Using Damien as leverage, he temporarily released Patricia to load the family car with various possessions: 2 VCRs, a phone, a caller ID, a CD player, watches, change, and a money clip with food stamps. He then returned Patricia and Damien to the kitchen, strapped them into chairs with rope and tape, and repeatedly pressed Patricia about whether she or her son should be killed first, while demanding Albert Jr.'s whereabouts. At approximately 3 p.m., Patricia Luna's 18-year-old daughter Rochelle arrived home. Jerf immediately took her to the bedroom, gagged her with tissue paper and tape, tied her wrists to the bed, and used a knife to cut off her clothing before assailing her. After the assault, he stabbed Rochelle 4 times in the chest and slit her throat, severing her jugular vein. According to the medical examiner, 2 of the chest wounds and the throat wound were each potentially fatal. Rochelle also had several shallow knife cuts to the back of her head inflicted while she was still alive, and 1 superficial stab wound to her right temple that was likely made after death. Her earring had been violently torn through her earlobe. At some point before dying, she vomited behind the gag and inhaled the vomit. Afterward, Jerf told Patricia that he had essayed and murdered her daughter. About an hour later, around 4 p.m., Patricia's husband, Albert Luna Sr., returned home from work. Jerf immediately overpowered him, handcuffed his wrists, and forced him to crawl to the master bedroom, where he made him lie face down on the bed. Jerf then used an aluminum baseball bat to strike Albert multiple times on the back of the head, causing 3 deep lacerations and splattering blood across the room. The medical examiner later determined that the hemorrhaging from these blows was potentially fatal. Believing Albert would not survive, Jerf removed the handcuffs, bound his hands and wrists with tape, and left him gravely injured before returning to the kitchen to inform Patricia that her husband was now dead. Jerf then turned his attention to 5-year-old Damien. He tried to kill the child by snapping his neck, but when he twisted Damien's head completely around and nothing happened, he released him. Next, he attempted to electrocute the boy by cutting an electrical cord from a lamp, stripping the wires, and taping them to Damien's scalp. However, the cord was later found unplugged at the scene, showing that the attempt had failed. Despite suffering from severe head wounds, Albert Luna Sr. managed to tear through the tape binding his wrists and stumbled into the kitchen, where he confronted Jerf with a pocket knife. In the ensuing struggle, Albert managed to wound Jerf seriously, but Jerf retaliated by stabbing Albert with such force that the knife pierced through his right arm and into his torso. As the fight continued, Jerf pulled out his 9mm gun and fired 6 shots at Albert, who collapsed in front of his wife and young son. Turning to Patricia, Jerf coldly asked, "Do you want to see your child die, or do you want your child to watch you die?" Without hesitation, he shot both Patricia and 5-year-old Damien in the head at close range, killing them instantly. Afterward, Jerf doused the victims' bodies and parts of the house with gasoline. His girlfriend, Emily Boswell, later testified that Jerf told her he had briefly lit a red fuse cord, but put it out when he saw neighborhood children outside and realized he couldn't leave unnoticed. To start a fire without drawing attention, he turned on 2 burners on the kitchen stove, placed an empty pizza box and a rag on top, and left the house. Jerf fled in the Luna's family car, which he had packed with stolen household items, and arrived at his apartment around 6 p.m. There, he encountered Boswell and claimed that he had been stabbed during a robbery attempt. He later went to the hospital, where he was admitted for treatment of his injuries. By a stroke of fate, the pizza box and rag never ignited the gasoline, preventing the fire from spreading. That night, Albert Luna Jr., who had not been home during the murders, returned around 11:45 p.m. after becoming increasingly worried when no one answered his repeated phone calls. Upon entering the house, he discovered the horrific scene, the bodies of his parents, sister, and little brother. In shock, he fled to his girlfriend's home and immediately contacted the police. On September 15, Jerf confessed to his girlfriend, Emily Boswell, that he had murdered all 4 members of the Luna family, describing in disturbing detail how he had carried out each killing. The next day, September 16, his friend Travis Webb checked him out of the hospital, but Jerf refused to return to his apartment. Webb instead arranged a motel room where Jerf stayed until September 18. While there, he repeatedly recounted the murders to Webb and also called another friend, Daniel Greenwood, in California, again admitting that he was responsible for the Luna family killings. On September 18, Phoenix police executed search warrants at Jerf's motel room, apartment, and car. They recovered numerous pieces of evidence linking him to the crime. Jerf was arrested that same day. When taken into custody, he was found carrying a handcuff key and a newspaper article about the murders. Jerf later confessed again, and as part of a plea deal, he pleaded guilty on August 16, 1995, to 4 counts of first-degree murder in exchange for the dismissal of other charges. He hoped this might spare him the death penalty, but on May 22, 1996, he was sentenced to death on all 4 counts. Showing no remorse, he mocked the ruling by saying, "They can only kill me once." On September 18, 2025, Jerf wrote a letter to the media in which he expressed remorse for his crimes and said he would not pursue clemency from the state. Richard Jerf was executed in Arizona, marking the state's second execution of 2025. The previous execution had been in March when Aaron Gunches was put to death. A 4-person team, including medical doctors and a phlebotomist, prepared syringes of saline and pentobarbital, inserted an IV, and administered the lethal injection. When asked if he had any final words, Jerf simply replied, "I do not." His last meal was a double cheeseburger with lettuce and tomato, deep-fried onion rings with ketchup, a slice of cherry pie with whipped cream, and a 20-ounce Pepsi with ice. When it seemed the wave of executions might finally end, another case emerged. 1 more inmate, 1 more final day. Anthony Todd Boyd, October 23, Alabama. Boyd, Sean Ingram, Marcel Ackles, and Quinte Cox worked together to kidnap and murder Gregory Hughley. On July 31, 1993, Boyd, Ingram, and Ackles sought Hughley over a $200 unpaid cocaine debt. Later, Quinte Cox joined, bringing a 9mm pistol that would be used in the crime. The group drove around in a blue van rented by Marcel Ackles and soon spotted Gregory Hughley. Sean Ingram exited the van with the gun, called Hughley over, and forced him inside, making him lie face down behind the front seat. They dropped Quinte Cox off at a Cooper Homes to meet later. Their first stop was a gas station, where Ackles filled a plastic container with gasoline. Then, Boyd, Ingram, Ackles, and Hughley drove to a quiet baseball field, with Boyd and Ingram keeping Hughley pinned down as he begged for his life. At the baseball field, Sean Ingram forced Gregory Hughley onto a bench, restraining him with tape while Anthony Boyd bound his feet. Hughley was completely immobilized, and Ingram poured gasoline over him, creating a trail that he then ignited. Boyd, Ingram, Ackles, and Cox watched as Hughley burned for nearly 15 minutes, struggling and rolling through the flames before finally dying. Since his 1995 conviction and death sentence, Anthony Boyd has repeatedly challenged his execution. In 2018, he even requested the U.S. Supreme Court to allow him to be executed by hanging or firing squad instead of Alabama's usual electrocution or lethal injection methods, but the court, along with lower federal courts, denied his request. Boyd has repeatedly sought alternative execution methods, requesting options like firing squad, hanging, or a medical aid in dying procedure, none of which are permitted under Alabama law. He also filed a lawsuit challenging Alabama's new nitrogen hypoxia method, claiming it constitutes cruel and unusual punishment under the Eighth Amendment, an argument shared by other Alabama death row inmates as well. The method was introduced as an alternative to lethal injection, which faced growing issues such as drug shortages, botched executions, and legal challenges claiming it was cruel and unusual punishment. Supporters argued that nitrogen hypoxia provides a quick, painless, and reliable death since the body can't sense oxygen deprivation. However, critics warned the process is potentially torturous and may violate constitutional protections, calling it experimental and ethically questionable. Beyond Alabama, nitrogen hypoxia remains a rare execution method. Louisiana is the only other state to have used it, becoming the second in the U.S. to do so. While Arkansas, Mississippi, and Oklahoma have approved it as an option, none have carried out executions with it yet. Currently, Alabama and Louisiana stand alone in using one of the most controversial execution methods in modern history. After the crime, all 4 men faced justice, but their outcomes varied. Robert Sean Ingram initially chose to cooperate with authorities. Representing himself, he agreed to plead guilty to a lesser murder charge in exchange for a life sentence with the possibility of parole on the condition that he testify against his 3 co-defendants to aid the prosecution. However, he eventually changed his mind and refused to testify against the others. Because he broke the plea deal, the state canceled it and tried him for capital murder. The jury found him guilty and he was sentenced to death. Marcel Ackles, who had rented the van and helped with the kidnapping, received a life sentence without parole, avoiding the death penalty despite his significant role. Quinte Cox, who supplied the gun for the crime, received a lesser murder conviction and a life sentence with the possibility of parole. He was eventually released. Boyd was executed on October 23 by nitrogen hypoxia. At 5:50 p.m., the drapes in the viewing room were open. Boyd was secured to the gurney in a cruciform position with straps across his arms and chest and a white sheet covering him from the chest down. He formed an L shape with his index finger and thumb toward the viewing chamber, and his brother, watching from inside, returned the gesture. At 5:51 p.m., Warden Terry Rayburn read aloud Alabama's authorization for Boyd's execution. Boyd lifted his head partway through the reading and gave a nod. At 5:52 p.m., Boyd delivered his final statement, proclaiming his innocence and asserting that he had not participated in any killings. He condemned the state's justice system as unjust, political, and motivated by revenge, stating that true justice comes from change, not executions. He urged others to continue fighting. I just want to say again, I didn't kill anybody. I didn't participate in killing anybody. Just want everyone to know there is no justice in this state. It's all political, it's all revenge motivated. There is no justice in the state, there can be no justice in the state. It's not about closure, because closure comes from within, not from an execution. I want all my people to keep fighting. You all matter. Let's get it. An Alabama Department of Corrections staff member ensured Boyd's mask was securely in place as he appeared to take slow, deep breaths with his eyes closed. Reverend Jeff Hood, Boyd's spiritual advisor, approached, took his hand, spoke with him, and made the sign of the cross. As the gas began flowing, Boyd's lower body jolted. He rolled briefly onto his side toward the viewing chamber and seemed to tremble and shudder. Hood remained at his side, partially obscuring the view of Boyd's face. Then, Boyd's body tensed with his legs lifting slightly off the gurney, then relaxed a few seconds later. Reverend Hood remained beside him, praying and making the sign of the cross twice as a blessing. Boyd continued to take deep, shuddering, and uneven breaths throughout. Hood stepped back and Boyd began taking deep, irregular, gasping breaths. The timing between breaths varied, sometimes 5 to 15 seconds apart. His shuddering gasps then sped up, occurring every 3 to 6 seconds, but with slightly less intensity. After a brief pause, he drew a sudden, deep gasp, followed by more chest-heaving, open-mouthed shudders every 3 to 5 seconds. His chest-heaving gasps continued, though his mouth remained closed. His brother in the viewing chamber remarked, "It's like he's gasping for air." Boyd's breathing became shallower, with choke-like breaths that slightly jolted his head. His legs danced briefly again and then relaxed while his breath stalled before another shallow gasp. At 6:16 p.m., Boyd's only visible movement was a slight twitch of his head. At 6:17, he took 2 breaths, one large gasp and one smaller, barely noticeable gasp, which appeared to be his final breaths with no other perceptible movements. From 6:18 to 6:27, Boyd remained still. Witnesses in the viewing chamber sighed, and one attorney shook his head while Hood appeared to wipe away a tear. At 6:27, the drapes were drawn, blocking the view of the execution chamber. Alabama Department of Corrections Commissioner John Hamm stated that the gas continued to flow for 5 minutes after Boyd's flat line. He admitted he didn't know the exact moment the gas started, how long it flowed in total, and when Boyd lost consciousness. However, he confirmed it was the longest nitrogen gas execution conducted so far. Boyd declined the final meal. He accepted his breakfast tray on the day of his execution, but refused his lunch and dinner. On the previous day, he was seen eating a cheeseburger, Reese's Cup, popcorn, Skittles, Starburst, and barbecue Fritos. He also drank strawberry Sunkist, lemonade, water, V8 Splash, and coffee. Finally, before October came to an end, the last execution of the month took place, closing a grim chapter in what became one of the deadliest months of the year. Norman Merle Grimm, October 28, Florida. On the morning of July 27, 1998, a deputy from the Santa Rosa County Sheriff's Office responded to a disturbance at Cynthia Campbell's home. Campbell reported hearing noises behind her house. When the deputy investigated, he did find a broken window and a chrome lug nut in the bushes. Before leaving, the deputy noted that Campbell's neighbor, Norman Grimm, had invited her over for coffee. Later that morning, 2 of Campbell's law office colleagues arrived to find her car in the driveway but could not locate her inside the house, prompting another call to the sheriff's office. When questioned, Grimm had reddish-brown stains on his shoulder and shorts, which he claimed were paint, not blood. That afternoon, 2 fishermen made a grim discovery. Cynthia Campbell's body was pulled from the water, tightly wrapped in a bedsheet and shower curtain, and secured with masking tape. The autopsy showed that Cynthia Campbell suffered severe trauma, including deep bruises and abrasions on her shoulders, face, and lips, consistent with hammer blows, as well as 11 stab wounds to her chest, 7 of which pierced her heart. The combination of blunt force trauma and stabbing caused her death. Investigators later uncovered extensive forensic evidence at Norman Grimm's home. In the kitchen, they found blood-stained mops, traces of blood on the floor and cabinets, and 2 bloody fingerprints on a box of trash bags. A stripped pillowcase with blood was inside the trash can. The dining room had blood spots, and in the living room were blood-stained jeans, athletic shoes, and the length of rope matching the one used to bind Campbell's body. On the back porch, authorities recovered a piece of green carpet matching the wrapping used on Campbell, her prescription glasses, and a cooler containing a steak knife, blood-stained clothes, men's underwear, a blood-marked tampon, a roll of masking tape, and a blood-covered hammer. Testing confirmed that all blood and genetic material matched Cynthia Campbell's DNA. At the time of Cynthia Campbell's murder, Norman Grimm was on parole for a 1990 burglary conviction in Texas. His criminal history in Florida was extensive, showing a long-standing pattern of offenses. Born in 1960, Grimm joined the Navy after high school, but he was discharged for unspecified misconduct. He briefly attended Pensacola Junior College before encountering legal trouble. In 1983, Grimm was convicted in Escambia County of unarmed robbery, armed burglary, kidnapping, and aggravated battery, serving several years in prison before being released in 1990. After relocating to Texas, he was again imprisoned for a store robbery, then paroled and transferred back to Florida. Upon returning, he worked reliably for about 4 years in a local manufacturing company's fabrication department. In 1997, Grimm married and moved to a home in Milton, Florida, though the marriage ended in divorce shortly afterward. Living nearby was Cynthia Campbell, who would later become his victim. One of Norman Grimm's earliest known attacks occurred on September 9, 1982, when a woman reported being assaulted while walking to work in Pensacola. Grimm grabbed her, choked her twice, and forced her toward his car, threatening to kill her. Thinking quickly, the woman tricked him into stepping away to retrieve her purse, then escaped by driving off. In another incident, a man noticed an intruder in his bathroom mirror and chased him out, only to hear screams from the neighboring house. There, a woman had seen Grim approaching with a knife. She fought back, sustaining a chin cut, and ran for help, while her brother chased Grim away. Grim also attacked a 14-year-old girl walking to school, dragging her into a wooded area. A nearby security guard intervened, frightening him off, though the girl suffered cuts, bruises, and torn earrings. When Grim was finally arrested for these attacks, police found him in possession of 2 stolen firearms and 35 rounds of ammunition taken during a residential burglary. Norman Grim, who had no visitors or spiritual advisor in his final hours, woke up at 6 a.m. and later ate his last meal, fried pork chops with mashed potatoes and a chocolate milkshake. When he was asked if he had any final words before the lethal injection was administered, Grim simply replied, "No, sir." As October came to an end, 7 executions had been carried out across the United States. In November 2025, 4 men on death row were set to be executed. 3 of them were, but 1 was spared at the very last moment. Tremaine Wood's life came to a pivotal moment on November 13, 2025, when Oklahoma Governor Kevin Stitt granted him clemency just hours before he was set to be executed by lethal injection. Wood, who had spent over 2 decades on death row, saw his death sentence converted to life without parole after a narrow 3-2 recommendation from the Oklahoma Pardon and Parole Board. In a public statement, Governor Stitt said the commutation reflects the same punishment his brother received for the slaying of Ronnie Whipf. He insisted that his decision still ensures public safety while sparing a life. Wood's conviction stemmed from a robbery gone wrong in 2002, during which Ronnie Whipf was stabbed to death. While Wood admitted participating in the robbery, his legal team has long maintained that he did not deliver the fatal blow. This claim was supported by the fact that his brother, Jayton Jake Wood, later confessed to the murder but had only received a life sentence. Prosecutors, however, pushed for his execution, arguing that Wood posed a continued threat, citing his prison record, including gang involvement, possession of contraband cell phones, and ordering attacks on other inmates. During his clemency hearing, Wood spoke via video from the Oklahoma State Penitentiary, pleading for mercy. "I'm not a monster. I'm not a killer," he told board members. He expressed deep regret, saying, "Not a day goes by in my life that I do not think about Ronnie and how much his mom and dad are suffering because they don't have their son anymore." For Wood's advocates, the case raised troubling questions about past legal missteps. His original defense attorney reportedly struggled with substance abuse and failed to challenge key testimony, while some evidence may have been improperly handled, factors that weighed heavily in the board's recommendation. The governor's decision, however, was not welcomed by everyone. Oklahoma Attorney General Gentner Drummond publicly opposed the commutation, arguing that Wood remained a dangerous man. "The danger remains as clear and present as ever," Drummond said, and vowed his office would continue working to keep Wood locked up. Just hours after his sentence was commuted, Wood was discovered unresponsive in his cell during a routine check. Officials then transported him to a nearby hospital, concluding that his collapse likely stemmed from extreme stress and dehydration. Wood later told authorities he must have rolled off his bunk after laying down, waking instead in the infirmary with a bruised head and split lip. He expressed gratitude towards Governor Stitt, reportedly telling officials, "Tell Governor Stitt I said thank you." Wood's clemency marked only the second time Governor Stitt has spared a life during his tenure, following the 2021 reprieve of Julius Jones. While the decision brought relief to supporters, it also underscored broader debates over justice, mercy, and the role of executive power in Oklahoma's death penalty system. As Tremaine Wood received clemency in Oklahoma on November 13, a Florida inmate had no such luck, preparing to meet his end. Brian Jennings, Florida, lethal injection. On the night of May 10, 1979, Brian Jennings, on a brief leave from his Marine duties, went out with friends before returning to the home of Rebecca Kunash. Observing her asleep through a window, he removed the screen, then climbed into the room. He covered her mouth, took her to his car, and drove to a secluded area near the Girard Street Canal on Merritt Island. There he essayed her, causing severe bruising and lacerations to her private area, using such force that he injured his own private parts. During the assault, he lifted her by her legs, carried her over his head, and swung her to the ground, fracturing her skull and causing extensive brain damage. While she was still alive, Jennings forced her into the canal and held her head under water until she drowned. Rebecca was only 6 years old. He was 20. Shortly afterwards, Jennings was detained for a traffic violation, and as the investigation unfolded, he was formally arrested for her murder. Although he initially denied involvement, he eventually admitted to the crime. Jennings faced charges of first-degree murder, kidnapping, essay, and other related offenses, with the prosecution seeking the death penalty. His recorded confession was admitted as evidence, and testimony from a former cellmate revealed that he had boasted about the crime. Forensic evidence, including fingerprints found at the scene, further linked him to the attack. Psychologists described Jennings as having a predatory personality and a disturbed moral compass, though he was found to be legally sane. In February 1980, Jennings was convicted of first-degree murder and associated charges. The jury recommended the death penalty, which was formally imposed in May 1980, along with additional life sentences for the other crimes. However, procedural errors led the Florida Supreme Court to grant an appeal in April of 1982, resulting in a retrial that reaffirmed his convictions and death sentence. Jennings continued to appeal his case over the years, leading to a second retrial in 1986, where once again he was found guilty and sentenced to death with consecutive life sentences for his other crimes. Over the following decades, Jennings filed multiple appeals challenging his convictions and sentences. The Florida Supreme Court, federal courts, and ultimately the U.S. Supreme Court consistently upheld his sentences. Changes in Florida law regarding jury unanimity for death sentences did not retroactively affect Jennings, and his appeals based on these changes were denied. Initially scheduled for execution in 1989, Jennings' sentence was stayed by the Florida Supreme Court. However, on October 10, 2025, Florida Governor Ron DeSantis signed a new death warrant, setting the execution date for November 13, 2025. Brian Frederick Jennings, now 66 years old, was declared dead at 6:20 p.m. after receiving a 3-drug lethal injection at Florida State Prison. When officials inquired if he wished to make a final statement, Jennings responded loudly with a firm no. Before the execution, he requested a last meal consisting of a single cheeseburger, a serving of fries, and a soda. Only 24 hours after this execution, all eyes were on South Carolina, where the next man's final hours were about to begin. Stephen Bryant, November 14, firing squad. Bryant was sentenced to death in South Carolina for killing 3 people in 2004, and after 21 years on death row, he was given until October 31 to choose his method of execution: lethal injection, the electric chair, or a firing squad. At the time of the murders, he was on probation for burglary. During the week-long spree, Bryant killed 3 men and seriously wounded a 4th, then answered calls from one of the victim's family members, even laughing as he told the daughter that her father was already dead. The killings occurred within a small 5-mile area of rural Sumter County. The sole survivor, 56-year-old Clinton Brown, was shot while fishing but managed to drive himself to the hospital. Former Sheriff Tommy Mims remembered the widespread fear gripping the community. Bryant's defense argued that severe childhood trauma and unresolved mental illness fueled his crimes. According to his attorney, he had been essayed by 4 male relatives and relapsed into drug use shortly before the murders. Bryant, who wrote an apology letter to one victim's widow, had a long history of instability. He was sent to the Department of Juvenile Justice at 11. He was diagnosed with emotional and intellectual impairments in school, and later with PTSD, ADD, and chronic depression. He regularly abused substances, including methamphetamine and Mary Jane, laced with Raid insecticide. In August 2004, a few months before the murders, he told his grandmother and aunt about years of essay. They sought help for him, and he contacted 2 agencies before the spree. One of the most disturbing killings was that of 62-year-old Willard Tejan. Bryant later said he had visited Tejan's home claiming car trouble. After hours of conversation, he shot him 9 times. He stayed in the house for hours afterward and smeared messages using the victim's blood. He left taunting notes including Victim 4 in 2 weeks, catch me if you can. Tejan's widow testified that when she called her husband's phone, Bryant answered and introduced himself as the Prowler, telling her her husband was dead. He then mocked Tejan's daughter when she called moments later, saying he had killed her father and laughing before hanging up. Another victim was Bryant's friend, 36-year-old Clifton Gainey, who was shot in the back and then fatally shot in the head as he tried to shield himself. Bryant took his truck and the steaks they had just bought. A third victim, 35-year-old Christopher Burgess, was found on a remote road. Deputies traced Bryant after reports of a suspicious truck. Bryant later claimed the man threatened him, though investigators found no evidence. A psychiatrist testified Bryant showed signs of paranoia. He received 1 death penalty and 2 life sentences. The U.S. Supreme Court refused to review Bryant's sentence. 4 inmates have chosen lethal injection since executions restarted. 2 opted for a firing squad. He eventually also selected the firing squad. 3 prison employees, each armed with live rounds, stepped forward as the volunteers tasked with carrying out the execution of 44-year-old Stephen Bryant. He was officially declared dead at 6:05 p.m. Bryant offered no final words, only lifting his eyes briefly toward the 10 witnesses present before officials lowered the hood over his head. Roughly 55 seconds after that, the rifles fired. Bryant did not make a sound. The red target patch positioned over his heart snapped forward from the force of the bullets. He took a couple of faint breaths, followed by a final convulsive moment just over a minute later. A physician listened to his chest with a stethoscope for about a minute before formally confirming his death. One reporter who witnessed the execution said that a noticeable damp area appeared on Bryant's chest where the shots struck. He wore black clothing during the procedure. 3 relatives of the victims, seated as official witnesses, held hands as the execution unfolded. For his special last meal, Bryant had spicy mixed seafood stir-fry, fried fish over rice, egg rolls, stuffed shrimp, 2 candy bars, and German chocolate cake. For the final execution of the month, we are heading back to Florida, where Governor Ron DeSantis signed more death warrants than any other state this year. Richard Berry Randolph, Florida, lethal injection. Randolph was convicted and sentenced to death for the murder of Minnie Ruth McCollum, the manager of a handiway store in Palatka, where he had once worked. On August 15, 1988, 3 women saw him at the store in a worker's uniform locking the door. When they asked why the store was closed and where McCollum was, Randolph claimed her car had broken down and that she had borrowed his so she could get home. After he drove off, the women looked inside and noticed the security camera was missing, wires were in the trash, and the store appeared ransacked. Alarmed, they called the sheriff. A responding deputy broke a window to enter and found McCollum on the floor, barely conscious, covered in blood and unclothed from the waist down. She was rushed to the hospital. Meanwhile, Randolph went to his girlfriend, Norma Janine Betts, and admitted that he had robbed the store and attacked McCollum. He told her he planned to go to Jacksonville to borrow money, cash lottery tickets, and later return to pick her and their daughter up so they could flee to North Carolina. Police arrested him at the Jacksonville grocery store where he was waiting for cash. Detective William Horde later testified that Randolph confessed after his arrest. He said he had hidden a toy gun behind the store and attempted to open the safe while the manager was outside. She returned and caught him, and a violent fight followed. Randolph admitted dragging her into a back room and beating her unconscious. When she came to her senses and screamed, he strangled her with the drawstring from his sweatshirt. Unable to open the safe, he took only a few lottery tickets. When she screamed again, he struck her, stabbed her, and strangled her a second time. Believing she was already dead, he essayed her to make it appear the work of a deranged stranger, then removed the security camera and fled. On his way to Jacksonville, he discarded his bloody clothes, shoes, and losing lottery tickets at a McDonald's, which police later recovered. Dr. Kirby Bland testified that McCollum arrived at the hospital comatose with devastating head trauma from multiple blows, deep lacerations to her scalp and face, a broken jaw, and stab wounds to her neck and near her eye. She died 6 days later from severe brain injuries. A psychologist testified that Randolph had a troubled and unstable childhood. Adopted as an infant, he struggled socially and spent a year in therapy during elementary school. His adoptive mother had repeated psychiatric hospitalizations, and his father abused him physically, once tying him up and beating him with a broomstick and a belt. Later in life, Randolph enlisted in the army, but he was honorably discharged because of Mary Jane and crack cocaine use. The psychologist stated that Randolph's long-term crack addiction played a major role in his behavior on the day of the murder. His biological mother actually found him back in 2022. She had him when she was 17 years old and gave him up for adoption. They were in contact for several years by phone or letters, but they never actually saw each other in person. She is now 80 years old. Randolph, 63, was declared dead at 6:12 p.m. after receiving a 3-drug lethal injection at Florida State Prison. The curtain to the execution chamber rose precisely at 6 p.m., the exact time his execution was set to begin, and officials started administering the chemicals 2 minutes later. Randolph offered no final statement. Once the injection commenced, Randolph kept his eyes shut and faint spasms moved across his face. His breathing was deep and labored for several minutes before his body became completely still and the color faded from his skin. Randolph showed no response and made no movement when the warden called out his name. A medical staff member entered the chamber at 6:11 p.m. and Randolph was officially pronounced dead moments afterwards. His final meal consisted of a cheeseburger, French fries, and ice cream. For the month of December, 3 people are scheduled to be executed, 1 in Tennessee and 2 in Florida. If all are carried out, Florida will have executed 19 people in 2025. If you ask me, DeSantis will try to make it to 20, so there is still a little bit of time for him to sign a final death warrant. He needs to give 30 days from the moment the warrant is signed until the execution happens. 3 men were executed in the month of December. Harold Nichols, December 11, Tennessee. On September 30, 1988, Harold Wayne Nichols entered a residence located in the Brainerd area of Chattanooga. Inside the home, he encountered Karen Bewley, who was alone in an upstairs bedroom at the time. Nichols proceeded to forcibly remove Bewley's clothing and to assay her. During the assault, he struck her in the head using a board he had found within the home. Following the initial assault, Nichols continued to hit Bewley in the head at least 4 more times while she struggled and attempted to resist him. Although one of Bewley's roommates discovered her alive, she ultimately succumbed to her injuries the following day. The official cause of death was recorded as blunt force trauma to the head, which had resulted in multiple skull fractures and severe brain injuries. Several months following the murder of Karen Bewley, on January 5, 1989, police officers took Harold Wayne Nichols into custody after receiving information linking him to a series of essays in the East Ridge area near Chattanooga which were not connected to the Bewley case. During questioning by officers from the East Ridge Police Department on January 6, 1989, Nichols confessed to multiple essays that had taken place in December 1988 and the early days of January 1989. Subsequently, when interviewed by Detective Richard Heck of the Chattanooga Police Department, Nichols admitted to committing the essay and murder of Karen Bewley. He also provided a videotaped statement in which he described in detail the layout of the victim's home and bedroom, the point of entry he used to access the residence, the events of the essay and murder, and the manner in which he disposed of the board used as the murder weapon. Following his confessions, Harold Wayne Nichols was initially charged with and subsequently convicted of multiple offenses involving 4 separate victims. These charges included aggravated essay and first-degree burglary committed on December 27, 1988, aggravated essay and first-degree burglary committed on January 3, 1989, 2 counts of aggravated essay and first-degree burglary also committed on January 3, 1989, and the combination of aggravated essay, first-degree burglary, and petite larceny that occurred on December 20, 1988. For the offenses involving 2 of the victims, Nichols pleaded guilty, accepting responsibility for the crimes. However, for the offenses involving the other 2 victims, he opted for jury trials, during which the evidence presented led to his convictions. Following his prior convictions, Harold Wayne Nichols entered a guilty plea to charges of felony murder, aggravated essay, and first-degree burglary for the crimes committed against Karen Bewley. At the sentencing hearing convened to determine the appropriate punishment for the felony murder conviction, the prosecution requested the death penalty, citing 2 aggravating factors. First, that Nichols had previous felony convictions involving violence, and second, that the murder of Karen Bewley occurred during the commission of a felony. During the hearing, the state presented evidence of Nichols' 5 prior convictions for aggravated essay, in addition to his videotaped confession detailing both the essay and murder. In mitigation, the defense presented evidence regarding Nichols' character and personal background. Reverend Robert Butler testified that he had known Nichols since childhood and described him as having had the best quality of character as a child. Similarly, Winston Gonia, a minister who had known Nichols since he was 10 years old, testified that Nichols was a good person. In addition, Reverend Charles Hawkins testified that he had visited Nichols on multiple occasions while Nichols was in an orphanage and had always found him to be a very fine young man. Reverend Hawkins further stated that he could not reconcile the violent crimes Nichols had committed with the person he had once knew. A co-worker, Larry Kilgore, also provided testimony in mitigation. Kilgore stated that he had worked alongside Nichols at Godfather's Pizza, considering him both a dependable employee and a friend. He described Nichols' work ethic, noting that Nichols had earned promotions up to assistant manager, had worked night shifts, and had handled various administrative tasks. Kilgore expressed his shock at Nichols' arrest, emphasizing that the person who had committed these crimes was not the individual he knew personally. Joanne Nichols testified on behalf of her husband, stating that she had married Nichols in 1986 and he had always been a perfect gentleman, describing him as kind, caring, and never mean to her. She explained that the couple had lived for a period with Nichols' father, whom she characterized as harsh and unloving. Joanne testified that her husband frequently worked late hours and sometimes did not return home at all during the night. Based on her observations, she did not believe that Nichols was capable of essaying and killing the victim, as he had never shown any indication that he would behave in such a manner. She acknowledged, however, that she had told an investigating officer that Nichols had said the murder was an accident. Finally, she emphasized that she did not want her husband to receive the death penalty. Nichols himself, who was 29 years old at the time of the sentencing hearing, testified regarding his family background. He stated that when he was 10 years old, his mother died of cancer and his father placed him in an orphanage. Nichols said he did not know the reason he had been sent there and could not recall experiencing any abuse during his time in the orphanage. In 1976, when he was about to be adopted, he was instead returned to his father, with whom he had a difficult and strained relationship. Nichols testified that he had joined the army and had received an honorable discharge in 1984. He explained that he had married his wife, Joanne Nichols, in 1986 and that he believed their marriage had been good. Nichols also acknowledged having a prior conviction for assault with intent to commit essay and having a daughter from a previous relationship for whom he had consistently paid child support up until his arrest. He stated he had enjoyed his work and had received promotions, advancing from a cook to assistant manager. Nichols described that when he engaged in acts of violence, he experienced a strange energized feeling that he felt he could neither resist nor control. He admitted that he had never sought help for his violent tendencies and had never told anyone about his criminal behavior. Regarding the murder of Karen Bewley, Nichols testified that he did not know her personally and that his original intent had been only to burglarize her home, not to kill her. He acknowledged that he was aware Bewley had been hurt during the attack, but admitted that he did nothing to help her. Instead, he disposed of the murder weapon and his clothing. While he expressed remorse for his actions, he conceded that he would have continued his violent behavior if he had not been arrested. Dr. Eric Engum, a clinical psychologist, testified that he had met with Nichols approximately 5 or 6 times and found him to be of high average intelligence and reasonably articulate. Dr. Engum diagnosed Nichols with intermittent explosive disorder, a condition characterized by an irresistible compulsion to commit violent and destructive acts until the behavior is carried out. He explained that this disorder can be influenced by organic factors or developmental factors, such as growing up in a hostile environment, experiencing abuse, lack of love, or abandonment. In Nichols' case, contributing factors included a harsh and hostile father and the abandonment he experienced when placed in an orphanage following his mother's death. Dr. Engum emphasized that Nichols was not a psychopath, nor was he inherently violent or evil at all times. He noted that Nichols' confessions reflected the responsible side of his personality, taking accountability for the actions of his destructive side. Engum concluded that Nichols would likely function well in a controlled, institutionalized setting, but if released, he would be at risk of repeating destructive behaviors. On July 17, 2020, Tennessee Governor Bill Lee granted a reprieve to death row inmate Harold Wayne Nichols, effectively halting his scheduled execution that was set for August 4, 2020. This decision followed the Tennessee Supreme Court's denial of 2 separate motions filed by Nichols requesting a stay of execution. The reprieve came shortly after Nichols had filed a civil rights lawsuit in federal court in which he argued that his execution date should be rescheduled. The motions submitted in state court emphasized the limitations and obstacles caused by the global situation at the time, which Nichols argued hindered his ability to properly file a clemency petition and prepare spiritually for his execution. With this action, Nichols became the first death row inmate in Tennessee to receive a reprieve or any form of clemency since Governor Lee took office in 2018. Nichols requested a final meal consisting of beef brisket, coleslaw, baked potato, onion rings, deviled eggs, cheese biscuits, and fruit tea. In his final statement from the gurney at Riverbend Maximum Security Institution, Nichols said, "To the people I've harmed, I'm sorry. To my family, know that I love you. To my friends, I love each and one of you. Beyond that, I know where I'm going, so I'm ready to go home." He also recited Psalm 23 and the Lord's Prayer with his spiritual advisor as the lethal injection began. He was pronounced dead at 10:39 a.m. Mark Gerald, December 12, Florida. The 8-year-old son of Tressa and Kevin Pettibone discovered his mother fatally battered and stabbed in the kitchen floor on February 1, 1989. Tressa Pettibone, 33 years old, suffered one fatal stab wound on the left side of her neck and two on the right. A knife discovered in the kitchen sink seemed to correspond with these stab wounds. Tressa's head, face, chest, and abdominal area all had numerous bruises and abrasions from physical trauma, according to the medical examiner. A plastic tie had been around her wrists for at least 20 minutes before she passed away. The victim's vehicle was among the other things missing from the residence. Before the murder, Gerald, a carpenter, assisted in remodeling the Pettibone family house. The following evidence linked Gerald to the crime. Gerald gave the victim's sunglasses to a friend. He pawned jewelry from the Pettibone home and had blood traces identical to Tressa Pettibone's blood type but not matching Gerald's blood type. Gerald's shoes corresponded with the shoes used to make tracks on the Pettibone's floor, and the plastic ties used to bind the victim matched ties discovered in Gerald's car. At the time of the crime, Gerald had a lengthy criminal history. He was found guilty in 1990 of grand theft auto, burglary, armed robbery, and first-degree murder. The Florida Supreme Court upheld Gerald's convictions and death sentence in 2006 after a jury unanimously recommended the death penalty for the Pettibone murder. In 1990, while awaiting trial for the murder of Tressa Pettibone, Mark Gerald made national headlines for a dramatic escape from the Bay County Jail in Florida. He escaped along with 4 other maximum security inmates. The group used saw blades to cut through the metal frame of a window. According to investigators, Gerald's wife was accused of smuggling the blades to him during a jail visit. After punching out the 6th-floor window, the inmates used a makeshift rope fashioned from bed sheets and blankets to climb down the exterior of the building. The escape was short-lived. Gerald and most of the other escapees were recaptured by law enforcement within hours of the break. The event was notable because the Bay County Jail was the first privately run jail in Florida's history. The security breach raised significant questions about the oversight and safety of private correctional facilities at the time. Gerald was first convicted in 1990. While his initial death sentence was vacated due to improper testimony regarding his past record, he was resentenced to death in 1992. In late 2025, he voluntarily waived his right to further appeals. Gerald declined a special final meal request. In his final statement, he addressed an inaudible name and said, "I'm sorry that I missed you. I loved you every day." He was pronounced dead at 6:15 p.m. at Florida State Prison following a lethal injection. Frank Atton Walls, December 18, Florida. Frank Atton Walls was executed on December 18, 2025 for a series of brutal murders committed in Okaloosa County between 1985 and 1987. His death marked Florida's 19th execution of 2025, setting a new single-year record for the state. Walls, known by investigators as the perpetrator of the Tuesday murders, was sentenced to death for the July 1987 home invasion and murder of Edward Alger, a 22-year-old Air Force airman, and his 20-year-old girlfriend, Ann Peterson. Walls ambushed the couple in their sleep, binding them with tape. When Alger managed to break free and fight back, Walls slit his throat and shot him in the head. He then shot Peterson twice in the head to eliminate witnesses. Following his 1988 conviction, DNA evidence and a plea deal linked Walls to 3 additional killings. Tommy Lou Windom, 1985. She was a 19-year-old whose throat he slit while she was sunbathing. Cynthia Sue Condra, 1986. She was a mother of 3 whom he stabbed 21 times. Audrey Gigi, 1987. She was a mother of 4 whom he essayed and stabbed to death just months before the Alger Peterson murders. His execution followed decades of appeals regarding his competency and claims of intellectual disability, all of which were eventually rejected by the Florida and the U.S. Supreme Courts. Wall's final meal request included chicken, steak, a baked potato, vegetables, cheesecake, and juice. He made a final statement that lasted about 1 minute before his execution. According to witnesses and news reports, his exact final words were, "Good evening, everyone. I appreciate the opportunity to say what's on my heart. If any of the members of the family are here, I am sorry for all of the things I did, the pain I caused, and all that you have suffered all these years." Walls was pronounced dead at 6:11 p.m. at Florida State Prison. A Catholic priest stayed with him throughout the process, holding his hand and praying over him. Stacey Ian Humphreys was scheduled for execution in Georgia on December 17, 2025, for the 2003 double murder of real estate agents Cindy Williams, 33, and Lori Brown, 21. However, on December 15, 2025, the Georgia State Board of Pardons and Paroles suspended the execution indefinitely to review a clemency petition amid allegations of conflict of interest involving board members. On November 3, 2003, Humphreys entered a model home sales office in Powder Springs where he forced the 2 agents to undress and provide their ATM pins at gunpoint. He then strangled and fatally shot both women, execution style. Prosecutors stated Humphreys committed the murders to obtain money for a payment on his truck. He withdrew more than $3,000 from the victims' accounts after the killings. He was sentenced to death in 2007. His appeals included claims of extreme juror misconduct, asserting a holdout juror coerced others into a unanimous death verdict after initial deliberations favored life without parole. Humphreys requested an extensive spread for his last meal, including barbecue beef brisket, pork ribs, a bacon double cheeseburger, French fries, coleslaw, cornbread, buffalo wings, a meat lover's pan pizza, vanilla ice cream, and 2 lemon lime sodas. Because the execution was suspended before it took place, no final words were recorded. The suspension followed the clemency petition highlighting the alleged juror misconduct and conflicts of interest, as 2 parole board members had past professional ties to the original trial's security or the victims' families. In 2025, 47 executions have been carried out in the U.S. Please hit that subscribe button if you like my channel. See you next time. Bye-bye.